figured. And, so I received your email last night and responded. That's not an issue, is it?
No, Your Honor.
Okay, so that's granted. You can do that. All right. So then what's your issue, Mr. Administrator?
Well, Your Honor, as you know, I wasn't present yesterday, but it's my understanding that we had an issue with regard to one of the jurors and an interaction, I believe, with our court reporter. And I was hopeful that we might be able to get that on the record and sort of flesh it out a little bit.
With the juror?
Oh, not yet with the juror.
Okay.
I think before we take that step, I'd like to have a full understanding on the record of what exactly the interaction was, whether or not, and most importantly this morning, whether or not the court received any notification from that juror that there was an out-of-court interaction.
I did not receive any correspondence from the juror. Nothing from the jurors. I'm just asking the bailiff to double check. Okay. So the full interaction, and I reported this yesterday, my understanding is Lou Taylor, our court reporter, spent the court reporter for most of the trial, went to dinner on Tuesday night, and the place where she went to dinner is apparently where this juror must work, because the juror was working as a hostess or a waitress. When the court reporter made eye contact with the juror, the court reporter told me they seemed to recognize each other. And the court reporter said to the juror, can't say anything about it. And the juror either said agree or nodded affirmatively, and that was it. That was it in terms of the verbal contact, although I understand that she then was the waitress or the person who brought the food and stuff to the table.
I see. Okay.
The juror number, yes. Anything else on that issue?
One moment.
Yeah.
Well, if you're satisfied that this interaction was benign, as you related, it appears to be, then we're satisfied that there will be no need to voir dire.
Okay. I am satisfied with that, and I think it's similar to, like Attorney Boylan said yesterday, that church experience that some of you, or I think it was you, Mr. Administrator, and everybody but Mr. Mendenhall. Yeah. I'm still wondering why he wasn't in church with you guys.
In all honesty, I missed the other stuff. He was trying to hook up his iPad.
All right, so that issue is resolved. Anything else in from plaintiff?
No, sir.
Okay, attorney.
Yes, sir.
Okay.
I had a request. That's something.
We're going to need a microphone, portable microphone.
Okay.
Also.
It's right on the podium. You're going to be the first to use it. So if you want to use it now or get ready to use it, I read the instructions first.
Right.
So you're probably going to have 20 to 30 minutes of,
Sure.
Getting organized.
Sounds good.
Okay. Attorney Guzzi.
Your Honor. As I was preparing my closing argument last night and going through the verdict form, and I'm not challenging anything on the verdict form, but it occurred to me that I needed some clarification, or we needed some clarification on the scope of plaintiff's argument.
On what?
On the scope of plaintiff's argument.
Okay.
It seems to me that the counsel's closing argument must be limited to breaches as identified in the enumerated questions on the verdict. In other words, they can't.
I don't think that's true.
I think it is. I think this is the form they agreed to. This is the form that sets out breaches or alleged breaches that the jury is to consider. And I think for them to bring in any other argument or any other allegation of breach of standard of care gets us into the territory of the Merkel case and the concept of negligence in the air. And if there is any such argument about a different or alleged breach of the standard of care, I believe that's grounds for mistrial. And if that occurs, just like in the opening statement, Judge, I will not make my motion during plaintiff's closing argument, but I will make it at the next break because I don't think it's appropriate.
Well, I'd encourage you to do it during the argument then, because I think we're talking two different things. When the verdict form was drafted, I specifically indicated that paragraphs 1A through 1D, 3A through 3C, and 5A through 5G are not limiting the answers to number 1, 3, or 5 respectively. So I think it would be a consistent verdict to answer yes to 1, but answer no to 1A, 1B, 1C, and 1D. And so if they're arguing other breaches in the standard of care that would fit under questions 1, 3, or 5, but are outside the scope of the subparagraphs of those numbers, in my opinion, that's not outside the scope of this case. It's not outside the scope of the presentation of their case. And in no way did I create those paragraphs to limit arguments. I did it, as I explained yesterday, there's a lot going on in this case. And there's declaratory judgment decisions that I'm going to need to make. And I thought it was appropriate to ask the jurors questions on that without signaling it. But also getting answers from them on things that I think are important to get answers to. So understanding your argument, but again, it's not inconsistent. In my opinion, if we get a verdict that answers 1 yes, 1A no, 1B no, 1C no, and 1D no, I think that's fine. That means that Dr. Schara, in their opinion, violated a standard of care that I didn't enumerate in 1A through 1D. If you remember their proposal, they wanted me to ask 21 different subcategories. I'm not doing that.
I understand that.
But they can argue those 21 because it would still fit under number 1. But I think you made your record. But if you're in this closing argument and it goes outside the scope of what I just said, then I want to address it right away because I think I'll be paying attention and understanding. But if it's outside the scope of 1A through 1D, for example, but not outside the scope of number 1, then your record's made.
So, for example, they can bring up the issue of informed consent as it relates to precedents. That's not something that's even within the consideration of those enumerated questions.
No, I think it'd be inappropriate to argue that Dr. Schara was responsible for the informed consent on precedents because he wasn't there on October 6th or 7th. The way that it was asked in paragraphs 3A and 3B of the verdict allowed them to talk about his take or Dr. Schara's take when he arrived on October 12th at 6 o'clock in the morning and the ongoing administration of it.
And that's the example. The scope in terms of precedents is limited to those 2 days. So any argument suggesting anything outside of those 2 days to me would be grounds for mistrial.
I don't want to argue their case for them, but if they were to argue that a reasonable doctor would have looked at the charts or the records and said there was this medical event on October 7th and another medical event on October 8th, and the doctor should have informed the family about it on October 12th, knowing that they hadn't been informed about it, which is what I think their argument's going to be. I think that's fair. But not linking him to the errors or the alleged errors that happened prior to October 12th at 6 o'clock.
Judge, I can represent from plaintiff's perspective that we've structured this closing argument so as to avoid the issue that Mr. Goosey's raised. So
I'm satisfied with the record I've made, and okay. If need be, I'm going to jump up and down and holler mistrial, but I will.
Has to approach.
Yeah.
Okay, Mr. Frankowiak.
I would concur with what Attorney Goosey just said, and I would join, obviously, his representations.
Okay, So we're going to take a break, Mr. Administrator, at 9:30. And so, you on that clock. So if you see it's getting close and it's 9:25 and that's a good spot for you to take a break, feel free to lead, tell us then. Or else at 9:30, I might remind you, how much longer, and then we'll just try to give them a break. Okay?
Sounds good.
All right, you may bring the jury in. All right, everyone may be seated. Good morning and welcome back, members of the jury. Hope you enjoyed your day yesterday. I missed seeing all of you. But we have a full day today. And before we get started kind of in the legal part of it, I just, on behalf of the parties and the attorneys and those of us who work in this building every day, I just want to say thanks for your commitment, your efforts, and all the time that you've put into this the last 3 weeks. It's admirable. It's inspiring. And I think it shows all of us that living in Outagamie County, when we have individuals like you who are serving in this capacity that you didn't choose to do, and you're given all those sacrifices, that we're very fortunate. So thank you. I'd like the bailiffs to approach. And I have 2 stacks of papers for the jurors, and so they're going to be handed to you. And I'm going to ask that you each get one of those, and I'm going to wait till you have those in your hands, and then I'll start explaining things. So each juror should have a packet, and on page one of them, it has a number 100 on top. If you look at that packet and just make sure that you have 18 pages. So the last page is 18 of 18. Okay. The other packet on the front page is called special verdict. And on the bottom of that special verdict page is 1. And then when you go to the last page, it should be page number 10. Okay, and it appears that each of you have both packets. So I discussed with counsel yesterday, and we're all in agreement that you have in front of you documents that you're each going to be able to take into the jury room with you. So when you're sitting around the table, you'll be able to go through it and not have to stand over somebody's shoulder and not be able to visualize it. You're also going to have these documents when I'm reading them to you. So I'm obligated to read to you the jury instructions, which is this packet of 18 pages. That's the law that we had talked about, at the beginning of this case. When you became jurors, I said at the end of the case, I'm going to instruct you to the law. So that's going to be the law. The special verdict form, which is the 10-page document, are the questions that you're going to be asked to answer. And when that verdict gets complete, you'll return to this courtroom and the clerk will read that into the record. I'm going to start my introductions or my comments when I before I read this law to you, I'm just going to tell you that this verdict form can be complicated, but I think it is simple if you just read the directions and kind of follow along. And all I'm going to do is look at page 1 as an example. So on page 1, question number 1 needs to be answered yes or no. When you get done answering that, in bold under that question are some directions. So you'll see on the verdict form throughout that the black bold is directions to you based on whatever your previous answers were. And for example, it says answer, questions if you answered yes to question 1. If you are a dissenting juror by answering no to question 1, then you should answer no to each of those additional questions. Okay? And then throughout. I will tell you, and you'll hopefully make sense when we go through it, that number 1 and 2 are kind of connected. Number 3 and 4 are connected. Number 5 and 6 are connected. And then 7 and 8 are connected. So it's really 4 sets of 2 questions. So I'm now going to start on page 1. You don't have to follow along if you don't want. As I'm reading, some people learn better by reading and seeing. Some people listen, and some of us do better by bold. So do whatever is comfortable for you. Members of the jury, this case will now be submitted to you in the form of a special verdict consisting of 8 questions, numbered question 1 through question 8. There are an additional 13 questions, numbered question 1A through 1D, question 3A through 3C, and question 5A through 5F that may need to be answered depending on your answers to previous questions. Your duty to answer those questions, which according to the evidence and my instructions, it becomes necessary for you to answer to arrive at a completed verdict. It then becomes my duty to direct judgment according to law and according to the facts as you have found them. Evidence is defined as follows: testimony of witnesses given in court, both on direct examination and cross-examination, regardless of who called the witness. Second, deposition testimony presented during the trial. Third, exhibits admitted by me, regardless of whether or not they go to the jury room. And number 4, any facts to which the lawyers have agreed or stipulated to, or which I have directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. You are to be guided by my instructions in your own sound judgment in considering the evidence in this case and in answering these questions. Do not concern yourself about whether your answers will be favorable to one party or to the other, nor with what the final result of this lawsuit may be. The court has allowed the use of charts to organize the evidence and to assist you in understanding it. The charts are a summary of some of the evidence that was presented. However, it is the evidence that controls. You should rely on the charts only to the extent that you believe it accurately and properly summarizes the evidence. The remarks of the attorneys are not evidence. If any remarks suggested certain facts not in evidence, you should disregard that suggestion. Consider carefully the closing arguments of the attorneys, but their arguments, conclusions, and opinions are not evidence. Draw your own conclusions and your own inferences from the evidence and answer the questions in the verdict according to the evidence and the instructions given to you by me. The lawyers for the parties have a duty to object to what they feel are improper questions. Do not draw any conclusion for either side if an objection was made to a question and the witness was not permitted to answer. If any member of the jury has an impression that I have an opinion one way or another in this case, you should disregard that impression entirely and decide the issues solely as you view the evidence. You, the jury, are the sole judges of the fact, and the court is the judge of the law only. I ordered certain testimony be stricken during this trial. You should disregard all stricken testimony and do not let it affect your answers to any of the verdict questions. Some questions in the verdict are to be answered only if you have answered a preceding question in a certain manner. It is important for you to read the introductory portion of each question carefully before you answer it. Do not answer questions you are not required to answer. I'm going to just full transparency here, okay? So if you go to page 1 of the verdict form, I don't know how many times I read this verdict form. It's over 100 times in the last week. But you guys catch the error that I have on there? I see one juror shaking his head. You're not supposed to shake your head yes that you saw an error. You're supposed to say, no, it looks great. So in that bold where it says, answer questions number 1 through A, everybody follow me? You see where it says through 1C? It should be 1D. So I'm going to modify that during the closing arguments, and the verdict, this is the official verdict form that I'm going to give to the jury room, and that will be changed in that one respect. So it's going to be 1A through 1D. But that's an example of why it's important to read those introductory paragraphs, okay? Agreement, I'm back to page 3 of the instructions. Agreement by 10 or more jurors is sufficient to become your verdict. Jurors have a duty to consult with one another and to deliberate for the purposes of reaching an agreement. If you can do so consistently with your duty as a juror, at least the same 10 jurors should agree in all the answers. I ask you to be unanimous if you can. At the bottom of the verdict form, you will find a place provided where dissenting jurors, if there are any, will sign their names and state the answer or the answers on the verdict questions in which they do not agree. Either the blank lines or the space below them may be used for that purpose. Certain questions in the verdict ask that you answer the questions yes or no. The party who wants you to answer the question yes has the burden of proof as to that question. This burden is to satisfy you by the greater weight of credible evidence to a reasonable certainty that yes should be your answer to that verdict question. The greater weight of the credible evidence means that if the evidence in favor of a yes answer has more convincing power than the evidence opposed to it. Credible evidence means evidence that you believe in light of reason and common sense. Reasonable certainty means that you are persuaded based upon a rational consideration of the evidence. Absolute certainty is not required, but a guess is not enough to meet the burden of proof. In considering the amount to be inserted by you in answers to each damage question, the burden rests upon each person claiming damages to convince you by the greater weight of credible evidence to a reasonable certainty that the person sustained damages with respect to the element or elements mentioned in the question and the amount of those damages. The amount you insert should reasonably compensate the person named in the question for the damages from the occurrence. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is the believability of the witnesses and the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider the following factors. Whether the witness has an interest or a lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity that the witness had for observing and for knowing the matters the witness testified about, the reasonableness of that witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and then all other facts and circumstances during the trial which tend either to support or to discredit that testimony. Then give to the testimony of each witness the weight you believe it should receive. There really is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. It's not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proven indirectly by what's called circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Usually, witnesses can testify only to facts they know, but a witness with expertise and/or specialized knowledge in a particular field may give an opinion in that field. In determining the weight to be given an opinion, you should consider the qualifications and credibility of the expert and whether reasons for the opinion are based on facts in this case. Opinion evidence was admitted in this case to help you reach a conclusion. You are not bound by any expert's opinion. In resolving conflicts in opinion testimony, weigh the different opinions against each other and consider the qualifications and credibility of the witness and the reasons and facts supporting their opinions. During the trial, the court received portions of published treatises and evidence. This evidence was not received to establish that the views expressed by the author are undisputed truths or absolute standards. The author's views should be considered as any other expert witness's opinion. You are not bound by the opinions expressed by the author any more than you are bound by the opinion of any other expert witness. During the trial, a witness with expertise and/or specialized knowledge in a particular field was told to assume certain facts and asked for an opinion based on those assumed facts. This is called a hypothetical question. Consider the opinion in the answer to that question only if you believe that the assumed facts which it is based. If you find that the assumed facts in the hypothetical question have not been proved, do not give any weight to that opinion. In providing care and treatment to Grace Schara, Dr. Gavin Shokar was required to use the degree of care, skill, and judgment which reasonable hospitalists who are in the intensive care unit would exercise in the same or similar circumstances, having due regard for the state of medical science at the time Grace Schara was treated. A doctor who fails to conform to the standard is negligent. The burden is on the plaintiffs to prove that Dr. Gavin Shokar was negligent. A doctor is not negligent, however, for failing to use the highest degree of care, skill, and judgment, or solely because a bad result may have followed his care and treatment. The standard you must apply in determining if Dr. Shokar was negligent is whether Dr. Shokar failed to use the degree of care, skill, and judgment that reasonable hospitalists in the intensive care unit would exercise given the state of medical knowledge at the time of the treatment in issue. If you find from the evidence that more than one method of treatment for Grace Schara's condition was recognized as reasonable, given the state of medical knowledge at the time, then Dr. Shokar was at liberty to select any of the recognized methods. Dr. Shokar was not negligent because he chose to use one of these recognized treatment methods rather than another recognized method, if he used reasonable care, skill, and judgment in administering the method. You have heard testimony during this trial from doctors who have testified as expert witnesses. The reason for this is because the degree of care, skill, and judgment that a reasonable doctor would exercise is not a matter within the common knowledge of lay people. This standard is within the specialized knowledge of experts in that field of medicine and can only be established by the testimony of experts. You, therefore, may not speculate or guess what the standard of care, skill, and judgment is in deciding this case, but rather must attempt to determine it from the expert testimony that you heard during this trial. In determining the weight to be given an opinion, you should consider the qualifications and credibility of the expert and whether reasons for the opinion are based on facts in the case. You are not bound by any expert's opinion. Question number 2 on that verdict form, which is on page 3 of the verdict form, asks, was such negligence by Dr. Gavin Shokar a cause of injury and/or death to Grace Schara? A person's negligence is a cause of plaintiff's injuries or death if the negligence was a substantial factor in producing injuries to Grace Schara and/or Grace Schara's death. This question does not ask about the cause, but rather a cause. The reason for this is that there can be more than one cause of an injury or a cause of death. You heard evidence that Grace Schara had COVID-19 in October 2021 and entered St. Elizabeth Hospital on October 6, 2021 as a result of COVID-19. The negligence of one or more individuals can cause an injury or death. In addition, the injury and or death can be caused jointly by a person's negligence and also the natural progression of the COVID-19. If you conclude from the evidence that the death of Grace Schara was caused jointly by Dr. Shokar's negligence and also by the natural progression of Grace Schara's COVID-19, then you should find that Dr. Shokar's negligence was a cause of her death. The evidence indicates without dispute that when Dr. Schokar started providing care and treatment to Grace Schara on October 12, 2021 at 6:00 a.m., she was inpatient in the intensive care unit at St. Elizabeth Hospital. Grace Schara's physical condition at that time cannot be regarded by you in any way as having been caused or contributed to by any negligence on the part of Dr. Schokar. This question, referring to question number 2, asks you to determine whether the condition of Grace Schara's health as it was when she placed herself under the doctor's care has been aggravated or further impaired as a natural result of the negligence of Dr. Shokar's care and treatment. Grace Schara sustained injuries before the treatment by Dr. Schokar. Such injuries had caused Grace Schara to endure pain and suffering and incur some disability. In answering these questions on damages, you will entirely exclude from your consideration all damages which resulted from the original COVID-19 condition. You will consider only the damages Grace Schara sustained as a result of the treatment by Dr. Schokar. It will therefore be necessary for you to distinguish and separate, first, the natural results and damages that flow from Grace Schara's original COVID-19 condition, and second, those that flow from Dr. Shokar's treatment, and allow plaintiffs only the damages that naturally resulted from the treatment by Dr. Schokar. Question number 3 on the verdict form asks, was Dr. Gavin Schokar negligent in informing Grace Schara and or her power of attorney about the availability of reasonable alternate medical modes of treatment and about the risks and benefits of those alternate modes of treatment with regard to the care and treatment on October 12 and 13 of 2021. A doctor has a duty to inform his patient about reasonable alternate medical modes of treatment available to the patient and about the risks and benefits of the treatments that a reasonable physician in the same or a similar medical specialty would know and disclose under the circumstances. If a physician fails to perform this duty to inform, he is negligent in informing his patient. A physician's duty to inform his patient does not require disclosure of detailed technical information that in all probability a patient would not understand, risks apparent or known to the patient, extremely remote possibilities that might falsely or detrimentally alarm the patient, information in emergencies where failure to provide treatment would be more harmful to the patient than treatment, information in cases where the patient and the patient's power of attorney is incapable of consenting, information about alternate medical modes of treatment for any condition the physician has not included in his or her diagnosis at the time the physician informs the patient. You have heard testimony during this trial from doctors who have testified as expert witnesses. This is because information about the availability of reasonable alternate medical modes of treatment and about the risks and benefits of the treatments that a reasonable physician would disclose to a patient in the circumstances of this case is not a matter within the common knowledge of lay people. The reasonable physician's standard of informing a patient is within the special knowledge of experts in the field of medicine and can only be established by the testimony of experts. You may not speculate or guess what the standard of informing a patient is in deciding this case, but rather must attempt to determine it from the expert testimony that you have heard during this trial. In determining the weight to be given any opinion, you should consider the qualifications and credibility of the expert and whether reasons for the opinion are based on facts in this case. You are not bound by any expert's opinion. A physician has a duty to provide the patient or patient's legal representative with the information that a reasonable physician in the same or a similar medical specialty would know and disclose under the circumstances. If a physician fails to perform this duty to inform, he is negligent in informing his patient or the patient's legal representative. You have heard testimony during this trial from doctors who have testified as expert witnesses. This is because information that a reasonable physician in the same or a similar medical specialty would know and disclose to a patient in the circumstances of this case is not a matter within the common knowledge of lay people. The reasonable physician standard of informing a patient is within the special knowledge of experts in the field of medicine and can only be established by the testimony of experts. You may not speculate or guess what the standard of informing a patient is in deciding this case, but rather must attempt to determine it from the expert testimony that you have heard during this trial. In determining the weight to be given an opinion, you should consider the qualifications and credibility of the expert and whether reasons for the opinion are based on facts in this case. You are not bound by any expert's opinion. Question number 4 on the verdict form asks, was such negligence by Dr. Gavin Shokar in informing Grace Schara and or her power of attorney a cause of injury and or death to Grace Schara? A physician's negligence is a cause of a patient's injury and or death if the negligence was a substantial factor in producing the patient's injury and or death. This question does not ask about the cause, but rather a cause. The reason for this is that there can be more than one cause of an injury and or death. Question number 5 on the verdict form asks, were one or more of the nurses at St. Elizabeth Hospital negligent with regard to the care and treatment provided to Grace Schara between October 6, 2021 and October 13, 2021? At the time in question, the nurses working in the intensive care unit between October 6, 2021 and October 13, 2021 were registered nurses serving in this capacity at St. Elizabeth Hospital. As registered nurses, it was their duty in treating and caring for Grace Schara to use the degree of care, skill, and judgment which reasonable registered nurses would exercise in the same or similar circumstances, having due regard for the state of learning, education, experience, and knowledge possessed by registered nurses at the time in question. A registered nurse who fails to conform to this standard is negligent. The burden is on the plaintiffs to prove that the nurses and or St. Elizabeth was negligent. A registered nurse is not negligent solely because a bad result may have followed the treatment and care of Grace Schara. The standard you must apply in determining if the nurses and or the hospital were negligent is whether the registered nurses at St. Elizabeth Hospital failed to use the degree of care, skill, and judgment which a reasonable registered nurse would exercise at the time the service was rendered. You have heard considerable testimony during this trial from experts in the field of nursing and medicine who have been called as expert witnesses by both sides. The reason for this is because the degree of care, skill, and judgment which a reasonable registered nurse would exercise is not a matter within the common knowledge of lay people. These standards are within the special knowledge of experts in that field of nursing and medicine and can only be established by their testimony. Therefore, do not speculate or guess what those standards of care, skill, and judgment are in deciding this case, but rather you must attempt to determine this from the expert testimony that you heard during this trial. In determining the weight to be given an opinion, you should consider the qualifications and credibility of the expert and whether the reasons for the opinion are based on facts in this case. You are not bound by any expert's opinion. Question number 6 on the verdict form asks, was such negligence by one or more of the nurses at St. Elizabeth Hospital a cause of injury and or death to Grace Schara? A person's negligence is a cause of a plaintiff's injuries or death if the negligence was a substantial factor in producing injuries to Grace Schara and or Grace Schara's death. This question does not ask about the cause, but a cause. The reason for this is that there can be more than one cause of an injury or cause of death. You heard evidence that Grace Schara had COVID-19 in October 2021 and entered St. Elizabeth Hospital on October 6, 2021 as a result of COVID-19. The negligence of one or more individuals can cause an injury or a death. In addition, the injury and or death can be caused jointly by a person's negligence and also the natural progression of COVID-19. If you conclude from the evidence that the death of Grace Schara was caused jointly by the negligence of the registered nurses at St. Elizabeth Hospital and also by the natural progression of Grace Schara's COVID-19, then you should find that the registered nurse's negligence was a cause of her death. The evidence indicates without dispute that when the registered nurses started providing care and treatment to Grace Schara on October 6, 2021, she was positive for COVID-19. Grace Schara's physical condition at that time cannot be regarded by you in any way as having been caused or contributed to by any negligence on the part of the registered nurses at St. Elizabeth Hospital. This question asks you to determine whether the condition of Grace Schara's health, as it was when she entered St. Elizabeth Hospital on October 6, 2021, has been aggravated or further impaired as a natural result of the negligence of the care and treatment provided by the registered nurses at St. Elizabeth Hospital. Grace Schara sustained injuries before the treatment by the registered nurses at St. Elizabeth Hospital. Such injuries had caused Grace Schara to endure pain and suffering and incur some disability. In answering these questions on damages, you will entirely exclude from your consideration all damages which resulted from the original COVID-19 condition. You will consider only the damages Grace Schara sustained as a result of the care and treatment by the registered nurses at St. Elizabeth Hospital. It will therefore be necessary for you to distinguish and separate first the natural results and damages that flow from Grace Schara's original COVID-19 condition, and second, those that flow from the care and treatment by the registered nurses at St. Elizabeth Hospital, and allow plaintiffs only the damages that naturally resulted from the care and treatment. The law provides that a physician is not responsible or vicariously liable for all care and treatment provided to a patient, including any negligent acts or omissions committed by others providing care and treatment to the patient. Therefore, you may not consider any testimony or argument suggesting that Dr. Gavin Shokar is responsible for the negligent acts or omissions, if any, by any other physician, nurse, or healthcare professional in providing care and treatment to Grace Schara, just because Dr. Shokar was the attending physician from October 12th and October 13th, 2021. The verdict form contains the following damage questions numbered 8A through 8C. The question reads, what sum of money will fairly and reasonably compensate plaintiffs for Grace Schara's death with respect to, and line A says funeral and burial expenses. I've inserted the answer to that question, so you don't have to answer it. And that number is $14,237.89. You'll see on the bottom of page 14, I've answered question A because the parties have agreed on the amount to be inserted. And then line B reads personal injuries for lack of informed consent. And line C reads past pain and suffering. I'm now down on the last line of page 14. You should not conclude from the fact that I answered question 8A as to the amount of damages that any party has admitted fault or that any party may be responsible for the amount inserted. Finally, you should not assume that because I answered question 8A that a party already has or necessarily will recover that amount. Parties may, as here, agree on the amount of damages without admitting that they are responsible for the damages. In answering the damage questions, completely disregard any percentages which you may have inserted as your answers to the subdivisions in question number 7, which is the comparative negligence question. In answering the damage questions, be careful not to include or to duplicate in any answer amounts included in another answer made either by you or by me. Your answers to the damage question should not be affected by sympathy or resentment, nor should you make any deductions because of a doubt in your minds as to the liability of any party to this action. Determining damages for pain and suffering and personal injuries for lack of informed consent cannot always be made exactly or with mathematical precision. You should award as damage amounts the amounts which fairly compensate the plaintiffs for their injuries. The amount you insert in answer to each damage question is for you to determine from the evidence. What the attorneys ask for in their arguments is not a measure of damages. The opinion or conclusions of counsel as to what damages should be awarded should not influence you unless it is sustained by the evidence. Examine the evidence carefully and dispassionately and determine your answers from the evidence in this case. In answering question 8B, you should consider this following paragraph. If you have determined that Dr. Schara was negligent in informing Grace Schara and her power of attorney, you will insert as your answer to question 8B the amount of money which under the evidence will reasonably and fairly compensate the plaintiffs for the injuries suffered by Grace Schara as a result of Dr. Schara's negligence. The law provides that the estate of a deceased person is entitled to be compensated fairly and reasonably for pain and suffering endured by Grace Schara from the time of the negligence up to the time of her death. Pain and suffering includes all physical pain and discomfort, worry, and mental distress. In determining the amount of damages for pain and suffering, you will consider the nature, extent, and duration of all physical pain and suffering, mental anguish, apprehension, discomfort, or sorrow the deceased consciously endured and suffered between the time of the negligence and the time of death, and insert as your answer such sum as will, in your judgment, represent reasonable compensation for such pain and suffering as you are reasonably certain Grace Schara endured and suffered as a natural result of the injuries from the negligence. Now, members, I believe that's where I'm finished until after closing arguments. Okay, so what we're going to do, just to put us on the same path, is I've told the attorneys, just based on the schedule that the jury likes, that we're going to take a break at 9:30, okay, which is an hour and a half from when we started. And we'll take that normal break so all of you can do what you've been doing the whole trial. I've also told them that when I'm done giving these instructions, I'm going to ask all of you to just take the papers that I gave to you and either turn them over and put them on your lap or put them on the floor beneath you or on the ledge around you. I don't want those to be a distraction when they're making their closing arguments. And so instead of collecting them from you and then turning them back, you know, I just ask that you either set them down or, and if they want you to reference, they'll tell you to look at a certain page and, or if they have it pulled up on a screen, they might tell you to follow along if you want, but I'm going to let them do that without those papers interfering. I also had mentioned that the plaintiff gets to go first in their closing arguments and they get to go last. So you're going to hear the plaintiff and then you hear from each of the defense and then you're going to hear from the plaintiff. And whenever that's finished today is when you're going to begin your deliberations. Mr. Administrator. Yes.
Good morning. Can everyone hear me? It's been a long road to get to this point. So first I want to thank you. I'm sincerely grateful for the fact that you folks have come to us promptly, daily, and you've given us what I consider to be your rapt attention to the evidence that we presented in this courtroom. What's wrong with it? I think he's altered it in my absence. Maybe. Okay. As I said, you've been incredibly attentive, and as the judge said to you, and I know that he was sincere when he said this has been a real treat for him, and he is truly appreciative as to the level of attention that you've shown. And we can tell that because this is what we do on a daily or weekly basis. Try these lawsuits, and you folks have asked pertinent and relevant questions, poignant questions that show us that you're paying attention. And we know that you've taken notes, and we've watched as you wrote things down based upon this testimony, and we recognize that it's not easy in a case like this. If you remember when we first had an opportunity to talk to one another in the voir dire process, when we were doing jury selection, we talked about the fact that this was going to be complex. This is among the kinds of lawsuits that you could potentially serve as a juror. This is probably among the most complicated, because we're asking you to apply what you've learned in this room regarding medicine and law. And those are two, as you can appreciate, very complex, among the most complex of things that we consider as a society. Judge, I want to thank you also personally on behalf of our team and the Schara family. When you mentioned that this was a treat for you, you've conducted yourself admirably to the highest levels expected of our profession. We have had several disagreements, many of which were done in your presence, many were done outside of your presence, and all of those were resolved amicably by true professionals. And as the judge said, you're not to consider those things, only to consider the evidence. Since you were here last, we've worked diligently to resolve many of the technical legal issues, but as the judge indicated to you in the instructions of law, there are 4 claims that are remaining for you to decide. The medical battery claim has been removed from your consideration by the court. You're not to consider anything or make any kind of an inference regarding that claim. It is not for you to decide. As I said to you folks at the outset, we have the burden of proof. And we talked about this during the voir dire process also. And we talked about what that meant. And I know that a lot of people have heard about the burden of proof being beyond a reasonable doubt. And we distinguished that burden of proof because it applies only in a criminal case. The burden of proof that the judge has given you today, that the law requires you to apply to the facts and the evidence in this case, is by a preponderance of the evidence, right? You may recall that I said to you at the very beginning, if you envision the scales of justice and you place one feather on those scales, if we were to place one feather, that is sufficient to prove this case by a preponderance. Literally, that's all it takes. We don't have to prove this case beyond a reasonable doubt. We don't have to prove it by clear and convincing evidence. One feather. I also told you during that voir dire process when we were going through jury selection that we already knew what the evidence was going to show. And as you've heard throughout this case, when we talked to the experts, for instance, from both sides, this case has gone on for over 2 years. And the discovery portion of it, meaning our ability to go out and uncover their opinions, has gone on for a number of years. And we knew what they were going to say. So I told you with confidence when we first began, that we felt we could prove this case by a preponderance of the evidence. Throughout that 2.5-year period, we have worked for years to bring you the evidence. We've conducted numerous depositions. We've crisscrossed this country from Santa Barbara to Baltimore and Florida, from a donkey ranch in Kanab, Utah, as you heard Dr. Goldberg say, and ultimately to Snellville, Georgia, in order to find out what these paid defense experts were going to try to convince you of. This case represents thousands of hours of work, and we appreciate your willingness to participate in the process and to take the opportunity to truly make an impactful decision. Grace died before she had a chance to live out her hopes and dreams, and this is her final say. We hope that the evidence that we have brought into this courtroom has helped you to sufficiently understand the medicine, as complex as it is. Your decision is designed to interpret whether or not the hospital and nurses and Dr. Shokar violated what we call the accepted standards of medical care, and that those violations contributed to the cause of Grace's death. You won't get that kind of guidance from the defendant's experts. The issue of credibility and what the judge described to you as the tests for credibility is crucial. So now, perhaps you understand, now that the judge has given you the instructions of the law, understand why it was that we took great pains to talk about how much money these defense experts were charging. You know, Mr. Fleiter had an opportunity to cross-examine Dr. Garibaldi, and Dr. Garibaldi from Northwestern down in Chicago admitted that he charged $12,000 to be here that day. That's nice work for a short period of time. I'm sure there isn't a person in this jury box that can say that they can make $12,000 for the amount of time he spent in this courtroom. Now, admittedly, he's got a really nice resume. But you remember that John asked him, well, would you do it for $10,000? And he said no. So he was adamant that $10,000 was his price. They spent hundreds of thousands of dollars to find experts that were willing to come into this courtroom and try to convince you that all of the defendants were perfectly clean, that they were perfectly acting within acceptable standards of medical care. It's for you to judge what that credibility, whether or not they had that level of credibility, made that witness tell the truth. We know for a fact, we've known throughout this country for years, that simply because a witness raises their hand to the bailiff and says that they swear to tell the truth, the whole truth, and nothing but the truth, that's not necessarily the case. So you need to look at the tests for credibility. You need to look at whether the witness has an interest or a lack of interest in the result of this trial. And that test goes primarily to the defendants in this case, to the hospital, to Holly McGinnis. You saw Nurse Haynes come in and testify, and Nurse Barkholz, Nurse Fisher, and all of them are still employees of Ascension and that corporate entity. And as current employees of that company, you have to ask yourself whether they have an interest or a bias that would perhaps color their testimony. You can also look, as the judge indicated to you, at the clearness or the lack of clearness of a witness's recollection. We had several instances in this courtroom over 2.5 weeks whereby people changed their testimony, whereby people were, it was pointed out, we had to take great pains to point out that in a deposition, a sworn testimony, deposition is a sworn testimony, it's not some street corner conversation or a bar stool discussion, it's sworn testimony. And so in that sworn testimony, they would say one thing and then come into this courtroom and say something completely opposite. When that happens, that goes to credibility. That witness has a lack of credibility, and it's up to you, the jury, to assess what to do about that. Do you disregard some or part or all of their testimony if they show that they have an inability to recall or that they change their testimony from one day to the next? And the court also told you that you can consider the reasonableness of a person's testimony. And that goes toward a lot of those medical experts, and whether or not what they tried to tell you about complex medical issues was really in fact reasonable, or did they try to muddy up the waters so that you would have to just throw your hands up and say, I just don't understand what this doctor's telling me, or this nurse. So it is up to you to determine what weight to give and whether or not to make an assessment as to their credibility of their witness testimony. So who was Grace? Grace was a sister, she was a daughter, she was an aunt, and she loved all three of those roles. You know, based upon the testimony, that she loved to dance. We showed a video of her at a dance recital. That she loved to fish, and she loved and was taught how to play violin. That she got a great deal of pleasure out of spending time with her dad. Even drove the truck. That she loved Elvis, and she was able to go down to Graceland and visit Elvis' home. You also know that before that fateful day in October of 2021, she had never been alone. This is a crucial fact in terms of trying to decide what happened in this case. And we have hammered home throughout. We talked about it to people in voir dire about advocacy, about having an advocate, and how important it was to have an advocate in a hospital setting. And this poor girl had never been alone. She always had an advocate. She had her dad by her side every day of her life, including when he ended up taking her into St. Elizabeth's in October of 21. She had the love of her sister who was caring for her throughout, and her mother. So, these are the facts. There's no dispute about most of these facts. Grace was admitted on October 7th through the emergency department at St. Eve's. She was admitted to the hospital as a precautionary measure because she was having difficulty with breathing. Grace was started on Precedex on admission on October 7th, and you've heard an awful lot about that drug. 10 p.m., they started the Precedex. 20 minutes later, Grace was already showing signs of being over sedated. We had a great debate throughout some days in this courtroom about whether she was, quote, over sedated or overdosed. Defendant's own expert, Dr. Bruce Goldberger, came in and testified. He agreed it was, in fact, an overdose. He was a toxicologist. He's the only medical doctor that came into this court and sat at that witness stand and told you from his toxicology perspective that it was an overdose. Nurse Haynes testified that he had to quickly slow down that drug, and her oxygen and blood pressure were crashing. And all of this is in the medical record. You've seen excerpts from the medical record. You've seen the signs and symptoms, the medical notes that indicate that her oxygen was crashing. This was a life-threatening event. Some people in the medical team didn't even know about it because they didn't bother to look back. They were going through this process of changing over from a paper medical record to Meditech, an electronic record. Some witnesses said, well, we couldn't even look back. You know, I mean, it was difficult. We didn't have the ability to look back. Even a matter of a few days, you didn't know what happened to your patient. And this is in the ICU. This isn't like somebody that's just put on 4B, you know, on a medical floor. No nurse ever told Grace's family that she had been over-sedated from that precedence. No one. They never knew of it. This was a clear breach of the standard of care. We brought Nurse Susie Eichinger into this courtroom, and she testified right there from that witness stand live, based upon her 37 years of nursing experience in ICUs all over the country, from Hawaii to Cape Canaveral, Florida. She reviewed all these medical records, and she looked at this nursing care, and in her expert opinion, she told you unequivocally that there were 13 itemized breaches of the standard of care for nursing. You can assess her credibility. Personally, it appeared that she was telling the truth. That's up to you to decide. Compare her testimony to that of Nurse Julie Davis, who came in from Snellville, Georgia, and admitted that after being licensed for 2.5 years, she became a nursing expert. And are you kidding me? She was a nurse for 2.5 years and decided to hold herself out as someone who could consult and give expert testimony about nursing. She didn't know anything. 2.5 years, she probably didn't know where the break room was. Unbelievably, the next day, on 10/8, the nurses turned Grace's Precedex back up, and as expected, she experienced a life-threatening overdose when her blood pressure dropped to critical levels. She required a central line. You've heard it called a PICC line. They placed a line directly into her heart in order to deliver the powerful resuscitation medications that she required. On October 8th, Grace almost died. And her dad, who was sitting in the room, was never told that her condition had reached such a dire level, and it was all as a result of the drugs that they had given her. Not telling Grace's family that she almost died from an overdose on October 8th was a breach of the standard of care. That's one more of the many tipped the scale. You're going to hear about the rest of them. 2 days later, well, first, in response to that overdose, the nurses turned off the Precedex completely later that day on October 8th. And after the Precedex was turned off, you saw testimony and saw aspects of the medical record which indicated that she was doing much better. Clearly, the Precedex had an impact on her ability to survive. 2 days later, on October 10th, her dad, Scott, was ejected from the hospital by Nurse Allison Barkholz. She came in here and testified that she was the supervisor. She made the decision based upon some complaints from her nurses that he was, quote, turning off alarms. And he testified about that. And he said he had asked the nurses how he could perhaps just turn down the volume or reset the alarm so that it wasn't making such a noise and waking Grace up in the middle of the night every 15 minutes or however long they were going off. If you've ever spent any time in a hospital, you know it's the last place you can get any rest during the night. So, once he was ejected from the hospital by an armed guard and he'd received no warning, Grace was left without an advocate. Some of you talked about what it's like to not have an advocate. It can be a critical decision. It can affect your ability to survive a hospitalization. You're a Down syndrome patient at age 19 who's never been away from her family, never been alone a single day in her life. The removal of an advocate without communicating any reason and the need to arrange for a replacement advocate was a clear breach of the standard of care. Now, the hospital wants to focus on Scott's behavior in order to distract from the fact that they totally failed to arrange for a replacement for him as an advocate. We call this tactic a red herring. You may have heard that term, red herring. It means a false topic. It means something to distract you. The shiny silver thing, look over here. It was a red herring. Had no bearing whatsoever on what happened in this, in terms of their medical care. This was a breach of the standard of care. The sheriffs were forced to hire an attorney so Grace would not be left alone with no one there to comfort her. Finally, the next day, you heard testimony that the hospital let Grace have some family. Jessica was in the ICU. She was allowed to stay until visiting hours were over, despite the fact that her father was ejected and she was there to replace him, despite the fact that she was an alternate on the power of attorney in the event that her mother and her father could not serve. We talked about that. They talked about, some people call it a POA. It was a power of attorney. Despite the fact that she had that status as a power of attorney and was serving as an advocate for a Down syndrome 19-year-old, she was told she had to leave when visiting hours were over. We introduced the hospital policy regarding visitors. What do they need a visitor policy for if their policy is no visitors because of COVID? On October 12th, Dr. Shokar came on board. He did make a care plan, and that included physical therapy and a plan to get her up and out of bed. He said that he reviewed Grace's medical chart and knew about the prior overdoses with Precedex, but he simply kept the Precedex going even though he had the power to shut it off. This is a clear breach of accepted standards of care. You may recall Dr. Burdine testifying that this wasn't a theoretical overdose of a medication that might have an adverse impact on Grace. This was a known adverse impact. This was a proven adverse impact from 3 or 4 days prior. We have that in the medical record. All you had to do was look at it, make a determination that the use of that medication, especially in combination with lorazepam and then morphine, could be the fatal cocktail that caused her death. Clear breach of the standard of care. That same day, Nurse McGinnis came on board, and Grace was her only patient. You heard her testify when I cross-examined her, because Sam Haynes had come in and he testified, oh yeah, he knows Nurse McGinnis. They were on the same ICU floor. In fact, Nurse McGinnis is the one who was the preceptor for him. In other words, the mentor or the trainer when he first came on in the ICU at St. E's. He testified that he was trained, and it's his practice as a nurse in the ICU to spend about 50% of his shift at the bedside. And Mr. Mendenhall cross-examined him, and he admitted that in a 12-hour shift, that would be about 6 hours of actual bedside care. And Nurse McGinnis testified later on. She sat here and heard his testimony, and she agreed with it. And she agreed that was her practice also, to spend about half of her time. In a 12-hour shift, that's 6 hours of bedside care. It becomes critical for you to keep that in mind when you look at her actions and her failure to act on October 13th. On the evening of the 12th, Grace was doing good. She had a FaceTime call with her family, and her oxygen levels were at 98 and 99%. Undisputed fact. Evening of October 12th. On October 13th, Grace would be oversedated, overdosed for the third and final time. And the day began at 7 a.m. when Holly McGinnis came on the day shift. The first thing that happened when she came on duty at 7 a.m., the very first thing she did was turned up the Precedex to a rate of 1. You've seen that chart. It will be in evidence. You've heard testimony about it repeatedly. And the purpose of that chart is to show you those vertical bars representing medications that were delivered to Grace throughout her last day, both Precedex, lorazepam, and ultimately morphine, and what times they were delivered. 30 minutes later, Nurse McGinnis turned up the Precedex to 1.1. This is the highest rate that Grace had ever received thus far. The rate of 1, you heard all sorts of testimony about titration and titration within limits, and these are all normal medications in the ICU. while they may be normal for other folks, they weren't normal for Grace Schara. That Precedex turned up to a rate of 1 at 7 a.m. on the 13th was higher than the rate that had almost killed her 5 days previous. So turned up to 1.1, then 24 minutes after that, turned up to 1.2. Around 8 a.m., Nurse McGinnis told Jessica that she needed to leave if she wanted to take a shower. Because it was COVID and these are negative pressure rooms. And you heard Mr. Frankowiak ask Nurse McGinnis about, well, why is that? Well, in their terminology, it was because if you took a shower in a patient's room, the shower would aerosolize the virus. So they made her go home in order to take a shower. She knew she was going to be there, anticipated that she was going to be there for a long time. So she left. While Jessica was gone, Nurse McGinnis put Grace into restraints. And then there was a dispute with her testimony, and she admitted that she was in error or she didn't remember whether it was restraints, whether it was mitts. She couldn't remember. At trial, she testified first that she didn't put her in restraints. I think we have a clip of the testimony for you. Dr. Schokar, who ordered the restraints? You or Dr. Schokar?
There were no restraints.
There are no restraints at all on the 12th or the 13th?
Correct. We used those mitts, those little sack kind of things for her feeding tube for a period of time and then took them off. But those are not, in my place of employment, considered a restraint, again, because the requirement is that she has free movement of her limbs. And so that was not a restraint.
You've seen this note before. Dr. Shokar's note. We've highlighted that portion. She required restraints. This goes to credibility. At 10:48 a.m., Nurse McGinnis turned up the Precedex once again to 1.4. You've heard testimony about that. It was the maximum allowable dose. Holly McGinnis totally failed to recognize that Grace had already been overdosed on a much lower dose. This was the point in her testimony when she admitted she had not reviewed the record, and there was all sorts of dispute between the nursing staff as to what you do when you turn over a shift, what you do when you take over. You know, it only stands to reason that if you're going to come off of a shift and someone's going to come in and replace you, that you're going to tell them what happened prior. I mean, it's incomprehensible that you would fight over whether or not you know what happened. Despite the fact that Dr. Shokar knew that Grace had required resuscitation after a much lower dose, he continued to allow the Precedex at the maximum rate for the entire morning, afternoon, and evening until just before Grace died, when he ordered it turned off. This was a breach of the standard of care. And Dr. Bourdain described Dr. Shokar's decision to allow the continued use of Precedex on October 13th as, quote, insane. That's the word he used. 8 minutes after turning up the Precedex to the maximum dose, Dr. Shokar entered a DNR order. Holly McGinnis acknowledged the DNR order at 11:08. Despite only having one patient and talking to Grace's sister Jessica about YouTube videos and music, she failed to tell her sister that there was a DNR order in place. 17 minutes after seeing the DNR order in the computer, Nurse McGinnis decided to give Grace lorazepam. We know that she was authorized to do that. It had been ordered by doctors. It's a known respiratory depressant. She admitted that she knew that. At 11:34, Holly McGinnis inserted a nasal feeding tube, and she used a bridle, which caused Grace to bleed all over her face from her nostrils. Nurse McGinnis never bothered to even clean up the blood, and it remained on her face until she died. You heard Jessica testify that that's the way she found her. Remember, Nurse McGinnis had a single patient. There was no dispute that the nurse to patients in the ICU on October 12th and 13th at St. Elizabeth was 1-to-1. For 12 continuous hours, she had one patient she was responsible for. At 4 p.m., Nurse McGinnis charted that there were no further interventions available for Grace. That's a fancy way of saying we aren't going to do anything to help you live. Despite the fact that she believed there was nothing available for Grace, at 5:46 p.m., Nurse McGinnis decided to give Grace another dose of lorazepam. An hour and 46 minutes after charting that there was no further interventions available. The Precedex had now been at maximum dose for almost 7 hours. Remember the side effects from the package insert that we talked about? Hypoxia, hypotension, and acidosis. And it had only taken Grace 20 minutes to become overdosed on October 7th at a much lower dose. They should have known that. Some nurses did know that. By this time, Grace was fighting for her life against metabolic acidosis. She was breathing incredibly fast in order to lower the acid levels in her blood. Dr. Shokar failed to recognize metabolic acidosis.
I hate to interrupt you 2 minutes after we adjourn. All right, so just before the jurors leave, because I'm sort of a type A personality, I'm going to substitute that first page on your verdict form with, I've modified it and changed it. So what I want you to do when you get up and leave is you can leave your packet on your chairs with the verdict form on top. And I'm just gonna have my staff go through it and replace your page 1 so it's up to the current version, okay? And if you could leave those on your chair, I take it that you're gonna need like 20 minutes? Is that okay? So we'll take a 20-minute break and we'll get you back in here. Jurors are excused.
You guys go back, but I'll give you one of these.
All right, you may be seated. Have you come out? So I handed to each of you the updated page 1 of the verdict form. The final form that's in front of me, the only change was 1C was changed to 1D in that one spot. I'm going to have Debbie just replace all the page 1s. I think instead of having a sidebar, Attorney Guzzi, go ahead.
Thank you, Judge. Counsel just argued that Dr. Shokar failed to diagnose a metabolic acidosis. Words metabolic acidosis do not appear on the verdict form in any of the enumerated questions. I think that is clearly outside the scope of the issues that in breaches that the jury is to be considering the issues as outlined in the enumerated questions. And on that basis, I'm moving for a mistrial.
Your motion is denied. During our discussions on the verdict form, at some point I labeled off all of the reasons or bases that the plaintiffs had for a breach in the standard of care for both Dr. Shokar and for the registered nurses. And I did it one time, if you remember, so I wouldn't have to go back and repeat it, but I'm going to go to the portion that's relevant. With respect to Dr. Shokar, Dr. Burdine testified that it was a breach in the standard of care for Dr. Shokar to fail to spot the metabolic acidosis, that it was a failure of Dr. Shokar to, in the standard of care, a breach of the standard of care for Dr. Shokar to not connect the maximum respiratory rate with the progressive metabolic acidosis, that it was a breach in the standard of care by Dr. Shokar to not diagnose metabolic acidosis as a cause of hypernia in Grace, who lost blood pressure, was receiving Precedex, and had abnormal total CO2. He further testified that Dr. Shokar breached a standard of care by failing to confirm metabolic acidosis with a blood gas and lactic level, that Dr. Shokar breached a standard of care by failing to treat metabolic acidosis with bicarbonate, and that Dr. Shokar failed to prevent a progression of metabolic acidosis by stopping the infusion of Precedex and failing to recognize hypotension as a complication of Precedex. Those were all his opinions regarding the standard of care. And as a result, this is a great example. So when I drafted 1 through D, it was in no way intended to limit the plaintiff from having any one of those or any combination of the ones I just rattled off be an answer to number 1. So for those reasons, your motion is denied, and if it was an objection, that's also denied. I think it's proper argument.
Further my record.
Okay.
None of those enumerated questions make any reference to a breach of the standard of care based on a failure to diagnose.
I think I disagree. So let me just repeat it for you. So I'm going to go back to the sheet directly from his testimony. So the first one I think that I rattled off, these aren't my words. This is Dr. Burdine testified that it was a breach in the standard of care by Dr. Shokar to not spot the metabolic acidosis, to not confirm metabolic acidosis, and by failing to diagnose metabolic acidosis as a cause of all the stuff that was happening to Grace. Those were the 3 that I just labeled. So those would be 3 that would say, no, those opinions do put blame on Dr. Shokar as a breach in the standard of care. That's my thought. But go ahead, I'll let you make your record.
Well, what the testimony is and what the alleged breaches are through that testimony, the way the verdict form is drafted, I don't think it's appropriate for there to be a failure to diagnose argument because that's not what they're instructed to consider in those enumerated questions.
They are instructed to consider it in answer to number one. In the enumerated 1A through 1D, I agree with you, but, and I'll just keep saying this, 1A through 1D is not in any way intended to limit the plaintiff from arguing breaches in the standard of care that have been put forth in front of the jury.
I've made my record.
Okay, good. Attorney Fleiter, you're just getting up like attorney and minister. Okay, so what we're going to do,
Judge,
1 second.
I would ask that when the jury returns, you'll indicate to them that the objection was overruled, that this is closing argument,
Sure.
standard admonition. There's no objection.
I don't think that there was an objection. I made that mistake a couple weeks ago, but I'll let them know that I thought it was proper argument. We had a chance to talk about it, so you're going to be able to pick up right where you left off.
Thank you. Thank you, Judge.
Okay.
Okay, quarter two.
Quarter two sound good? And then the people who are here will be the same people that are allowed back in, Kevin? Okay, we're adjourned. All right, everyone may be seated. Welcome back, members of the jury. If you have your packet in front of you, you can look at page 1 of the special verdict form. And on that first bold line that begins with answer, I replaced your page. So the line says answer questions number 1A through 1D. So the only change was that D. But you now have an updated, and that will be the same as the final special verdict that'll come into the jury room. The second thing I just wanted to mention before Mr. Administrator continues is we had a discussion. I made a decision that Attorney Administrator's arguments were proper, and so I'm just going to allow him to continue where he left off. Mr. Administrator.
Thank you, Judge. So, where we left off, instead of turning off the drugs that were killing Grace, Dr. Shokar ordered more. Dr. Holly McGinnis gave the lorazepam. Dr. Shokar ordered another dose, and he never got consent for this drug. This was also a breach of the standard of care. He claimed at trial that the first dose wasn't working enough, but he also admitted that it takes 10 to 30 minutes for lorazepam to reach peak effect. So he really had no idea how that first dose was working when he ordered the second. After 7 hours of maximum Precedex and 3 doses of lorazepam, Grace's blood pressure crashed through the floor. At 6:09 p.m., Nurse McGinnis charted that Grace's blood pressure was undetectable. At this point, Grace was breathing as fast as she possibly could. Her chest was heaving, and she fought against those drugs that were taking control of her respiratory status. Dr. Shokar claims that he looked at Grace's medical records and knew about Grace's prior overdose, but he somehow still failed to realize that Grace was being overdosed for a third time. Instead of turning off the Precedex and stopping lorazepam, Dr. Shokar did the worst possible thing. He gave her a drug that lowered her pressure further and stopped her from breathing. Stopped her from fighting the overdose, which slowed her breathing. At 6:15 p.m., Dr. Shokar directed Nurse McGinnis to administer morphine to a patient without a blood pressure, and he never got consent for this drug. It was a breach of the standard of care, and you heard Dr. Bedeen testify that this was the worst clinical decision he had seen in over 46 years of medical practice. The medical record states that the Precedex was left on at the max rate for 22 minutes after the morphine had been given. Dr. Shokar said that the medical record is wrong because it certainly doesn't make him look very good. He also says that the timing of the 2 lorazepam doses are wrong. And if the times are wrong, how can anyone know when to give the next dose? I'm sure that all of you who have children recognize that it's important to keep track of even how long a span is between a dose of Tylenol. By the way, remember when Dr. Shokar said he didn't know Jessica was the power of attorney? And one of you asked him about it. He said he did remember. These are the types of factors that go toward an examination of the credibility of the witness. Shortly after the morphine, Grace's sister knew that something was wrong. She felt that Grace's skin was cold. And we know now it's because she had no blood pressure and no circulation. Jessica went out into the hallway and asked Nurse McGinnis for help. Once again, this is on the 13th, the last day. Despite the fact that Nurse McGinnis had a single patient, didn't bother going into the room. Instead, she told Jessica to get a blanket and told her to go in there herself and cover her up. Jessica was obviously concerned, and she saw that Grace's numbers had started to crash. She called her parents on a FaceTime call, and her parents told her to get the nurses. She responded that the nurses wouldn't come in. Grace's parents are screaming through the FaceTime, "Please save our daughter." No nurses respond, and the nurses in the hallway that did talk or did respond to Jessica and her plea for help indicated for the first time that Grace was DNR. The entire family was screaming at the nursing staff that she is not DNR and please save our daughter. The nurses said there was nothing they could do, even though reversal drugs can be used. Even if there is a DNR, we now know that. Dr. Berdeen testified about what should have been done.
At the time the DNR was revoked there on the 13th, was treatment futile at that point?
No.
Okay, Grace could have been saved.
Yes.
Okay, and even given the overdose that you've talked about in this case on the 13th, what was Grace's chance of survival if treatment would have been given based on your experience of drug overdose?
Well, at this time, because you're dealing in part with a narcotic or opioid or overdose, reversal with naloxone, brand name Narcan, it can appear magical. I have seen people brought in who had no heartbeat for 20 minutes and were getting manual CPR.
Relevance. Overruled. Go ahead.
And we're getting manual CPR en route to the hospital. And after an amp of Narcan, in 10 seconds, they sat up out of the bed, went from lying flat, completely unconscious and unresponsive, to sitting up, talking.
Doctor, you just talked about Narcan, the morphine reversal drug. What other treatments should have been given at this time?
There is a reversal drug for benzodiazepines. Its slang name is Reversed, because Versed is a benzodiazepine, so Reversed. I can't pronounce the generic name, but that was available. Unfortunately, there's no reversal agent for Precedex, but Precedex could have been stopped, and that would have been the first step. And since Grace was suffering from metabolic acidosis, the administration of bicarbonate could have been done. And since Grace was hypotensive, the same measures that were taken on the 8th with norepinephrine and dopamine could have been done.
Further, at this time, regardless of whether the DNR was valid or not, the DNR was absolutely revoked. Nurses did nothing. No one came in the room. The total failure of nursing to respond to the family's pleas to save Grace was a breach of the standard of care. This is the first time the family had ever heard that Grace was a DNR. The family had no way of knowing that the DNR was on the record because they didn't access the record until Grace was dead. Play a clip from Nurse Julie Davis, the defendant's nursing expert. Well, you reviewed the medical record, but was the family given access to the medical record in your experience?
No one's ever given access to a medical record when a patient is in the hospital because it's active. You're still continuing to add to the medical record. So no one will ever get access to it until a patient is concluded with care.
Or dead?
Concluded with care, yes.
Concluded with care or death. Dr. Shokar totally failed to properly inform the family that Grace was a DNR. This was, in fact, a catastrophic breach of the standard of care. There should never be any confusion about whether a 19-year-old girl is a DNR or not. There's never any excuse for confusion on that issue. To make matters worse, Holly McGinnis testified that she might have forgot to put the purple DNR wristband on Grace. Then the next time she testified, she said the wristband policy wasn't in effect when Grace was in the hospital. I want you to listen to these clips and decide for yourself whether it sounds like Nurse McGinnis didn't remember the first time she testified.
And I know they're gonna add, what does a paper chart mean?
Okay, so now we do everything on the computer, but we used to have like a book outside the patient room and a shelf that would have this information that you're asking about on. That's the paper chart, maybe similar to a clinic if you've ever been to and they walk into the room with something.
Okay, so just, let me just make sure. So go back to the original question that the juror asked. The DNR order then would be outside of the door in a book?
Correct.
Okay, and then it would also be on the computer and it would also be potentially
On her wrist, yep.
Okay, and in Grace's situation, was it in the book outside of the room?
Yes.
Okay. Any other questions from the juror based on that? Okay, Mr. Administrator, back to you.
If she were a DNR, it would not only be in the chart, but she would have a wristband. Correct?
We usually try to indicate that, yes.
But if she didn't have a wristband that said she was a DNR, that would have been simple. The explanation for that would be simply that you forgot to put it on. Is that what you just said?
If she didn't have one on, it would be because I had not put it on. It's similar to what's printed out for an admission wristband.
It's not a metal bracelet, is it?
No, it is not. It's a plastic bracelet.
Thank you.
Any follow-up on that?
What color is the wristband?
Purple.
And is that confused with the admission wristband? What color is that?
That one's white. It is not confused.
Thank you.
Grace died 1 hour and 12 minutes after Holly McGinnis gave her morphine. You can hear how her voice is quavering in that clip. Despite the fact that Grace was about to die, Holly McGinnis left the ICU promptly at 7. Even the break room where she was changing, as according to her testimony, was the distance from that witness stand to the door of the courtroom. And she admitted that she had clocked out at 7:36. You may recall that I asked her to identify her time card. And she testified that she could identify that, and it showed that she clocked out at 7:36. Dr. Shokar left the ICU even before that. The defendants are going to come up here after me, and they're going to tell you a very different story. They're going to try to convince you that Grace wasn't overdosed on October 13th. Like she was on October 7th and 8th. And they've hired experts from all over the country and paid them over $100,000 to tell you everything went Dr. Mary Beach came in. She's an ethicist physician at Johns Hopkins. She admitted that the October 8th overdose was in fact a life-threatening event. Nurse Julie Davis, a professional witness, she started making money as a witness within 2.5 years of becoming a nurse, and she said everything was perfect, despite the fact that Dr. Berdine and Dr. Shokar's ethicist agreed that Grace could have died from an overdose on October 8th. She started off by telling you that everything that Nurse Susie Eichinger said under oath from that witness stand, detailing 13 separate breaches of the standards of nursing care, she didn't agree with a single one. Dr. Garibaldi came in and he testified on behalf of Dr. Shokar. He testified that he formed his opinion relying on an arterial blood gas test that actually didn't exist. When he first gave his opinion in this case, he said that this blood gas was definitely proved that Dr. Berdine was wrong. Then when he testified in court, he said that it didn't matter that he was wrong, and no one really looks at those numbers anyway. The blood gas test was the absolute best way to test for the metabolic acidosis that ultimately killed Grace. Dr. Bruce Goldberger came in. He testified from his ranch in Utah, and he offered no opinions about what the standard of care was in this case, but he did admit that Grace was overdosed on Precedex. Dr. Binstock came in on behalf of the defendants. He was a radiologist, and he testified, agreeing that the films that he reviewed, chest x-ray films, were subjective. He testified under oath that the x-ray on the day Grace died showed that she was getting worse. Dr. Berdine disagreed, testified that he read thousands of x-rays on a daily basis in his practice in the ICU at Texas Tech. You'll recall that Dr. Berdine is a professor of medicine, and he teaches students that are learning to be ICU critical care physicians. Even the hospital radiologist and Dr. Shokar's expert disagreed with Dr. Binstock. Compare these experts with Dr. Berdine and Nurse Susie Eichinger. Dr. Berdine wasn't making $1 on this case. He testified that he had never reviewed a case for a plaintiff before, that he had done, I don't know what he said, 100 reviews or more than 100 some reviews, medical negligence cases, always for the defendant. Always. This is the first case he ever came and testified about on behalf of a plaintiff. Let's play Dr. Berdine's clip.
So you're here serving as an expert, but you're not making a single dollar off this case, is that right?
That is correct.
Please tell the jury why you agreed to do that.
This case, so as a background, since I came to Texas Tech University Health Sciences Center 16 years ago, all of the malpractice cases that I have testified in prior to this one were for defendants. I was defending physicians against malpractice claim. This is the first one where I've testified on behalf of a plaintiff. The reasons are because the breaches of the standard of care were egregious, and I could not live with myself without answering the call to review and give advice on this case. So during my testimony, we have gone through a number of things that I've identified as breaches of the standard of care. My reports are very long. The number of the breaches of standard of care I identify in my reports are too numerous to count, but some of them stand out. One was the manner by which the father, Schara, was evicted from the hospital and its impact on the outcome in Schara. And I found this to be shameful conduct on behalf of the hospital. The second issue were the breaches of standard of care related to informed consent. And I find it indefensible that this patient was given medications, very dangerous medications, not theoretically dangerous medications, but medications proved by the medical record to be dangerous to this patient without informed consent. The events on the 13th are very difficult to recognize. The repeated administration of Precedex on the 13th was not just a breach of the standard of care, it was insane. The administration, excuse me, the administration of morphine on 10/13 to a patient who was unconscious, unresponsive, had lost her blood pressure, had no palpable pulse, and whose respiratory pattern was screaming to anybody who would look, metabolic acidosis. The administration of morphine in that situation is, or was, the worst clinical decision I have ever witnessed in over 46 years of medical practice.
Let that sink in. Ladies and gentlemen, mistakes do happen. But when we make a mistake, we need to own that mistake. Instead of owning their mistake, these defendants have spent 3 weeks now denying the obvious. Grace was overdosed on October 7th and October 8th using the same drug that they gave Grace on the day that she died. Except on the day that she died, she was receiving 40% more, plus lorazepam and morphine, which actually do increase the power of that Precedex. People got COVID and people died of COVID. That doesn't mean that everyone who had COVID dies. In fact, it doesn't mean that it was impossible to overdose someone just because they were being treated for COVID. Dr. Berdeen testified that only 1.4% of the people who had COVID died throughout this country. The defendants have tried to tell you that it was impossible to overdose Grace because she was receiving Precedex at a normal rate. How many times did we hear defendants, experts, nurses testify? Great. We use these drugs in the ICU all the time. This was a titratable medication. We were titrating this drug within the parameters that were prescribed, and we use it all the time. Defendants had cold, hard evidence in the record that they were giving Grace too much medication. And just like at this trial, they just kept saying, COVID, COVID, COVID. She had COVID. She died from COVID. There was nothing we could do. Whether or not the defendants have to own their mistakes is now up to you. I'll have a moment where, several moments, where I'll be able to listen to the defendants explain their side of the story. And then I'll have another opportunity, because we have the burden of proof, to come before you and give additional closing argument. Thank you for listening.
Attorney Frankowiak?
In a couple of years, money COVID-19. During the Johnson, Schara may not fully believe in not. Ray Schara died as a result. Right here, yesterday. COVID-19 is not replaced. Make no mistake, that was the problem. Once you reach the inescapable conclusion, COVID-19 exists. The hospital and its nursing staff in this case, it's been my privilege to present the case to you on behalf of the hospital and the nursing staff that performed heroic and enduring this lengthy period. Certainly embrace this case as well. I want to start off by clarifying things first. There are a couple of things that are not at issue with respect to the hospital. For example, questions of informed consent for medical procedures, medical administration, or the entry of a DNR. You've heard some terms like informed consent come up before. St. Elizabeth Hospital and its nursing staff had no duty to obtain informed consent in October 2021 of a patient or patient family for medical procedure, administration of medication, transfer to DNR order. That's been testified by the you also won't be asked to answer questions related to the propriety of the administration of medication by the hospital staff. The medications that form the basis of the plaintiff's theory in this case, we've heard those over and over, Precedex, lorazepam, morphine, were administered to Grace on October 13th by health testified at that time. But no expert expressed any criticism of health administration of medications, if you'll recall. If you think about that for a second, 2 weeks of trial we've had focusing on the administration of these medications, and not one expert was critical of poly or a single nurse for administering that medication. Dr. Bardine expressed no opinion with regard to Nurse McGinnis or her administration of medication. Grace. In fact, Dr. Bardine specifically testified that he was not advancing in this case opinions that any of St. Elizabeth Hospital's nurses felt above the standard here in the administration of medication. He admitted he didn't even review the deposition of Nurse McGinnis before he finalized. He had all the other depositions. but he didn't have her. Never. Nurse Eichinger, plaintiff's nursing expert, offers no criticisms related to the medication administration. These are not issues you'll be asked to consider with respect to the hospital. Now, attorney administered did make some mention of October 10th, when Mr. Schara was asked to leave the hospital. Allison Barco, who her testimony from Allison, charge nurse, told Mr. Schara that he would leave the hospital. It was not by armed guard. In fact, we had testimony. There are no armed guards in the hospital. In fact, as Allison testified, the security guard was there for the purpose of being extra careful. Help Mr. Schara remove his items because with COVID being in full bloom at the time, they needed all the nurses up. Nurses were up. Allison was very concerned based on being that Mr. Schara was so ill might not make it to this car. That's why that started. Now, Nurse Marcos' request to Mr. Schara to leave the hospital in the morning had nothing whatsoever to do with racism. Had nothing to do with her cause of death, acute respiratory failure with hypoxia. Had Scott remained in the hospital with Grace after the morning of October 10th, nothing would have changed relative to her COVID infection. Had Mr. Schara remained in the hospital with Grace after October 10th, nothing would have changed relative to Grace's development of severe respiratory distress. Had he remained in the hospital after October 10th, nothing would have changed with regard to the appearance of X-rays that we saw that proved the severity of Grace's COVID. Scott Schara's presence at Grace's bedside at any time after October 10th would not have slowed Grace's hyperventilation. It would not have rectified her severely depressed oxygenation saturation any more than Jessica's presence at Grace's bedside on the 15th were able to do so. Whether or not Scott Schara was present at Grace's bedside on October 13th would not have prevented COVID-19 from invading Grace's lungs, advancing as it did, and literally taking her breath away. I want to talk a little bit about what we've heard. I want to go over very as briefly as I can. We've heard from various witnesses. There's been a number of them, but each one of them had a little part to play in the song. Each one of them gave us some puzzle pieces that we work when we try to figure out exactly what happened. We first heard from Cindy Schara, who confirmed a few points of note. By her personal observation, her husband, Scott Schara, was in fact visibly exhibiting symptoms of COVID on October 10th. In fact, her husband confirmed to her that morning that he felt as if he contracted it. He also confirmed that Mr. Schara was subsequently hospitalized himself as a result of the COVID infection, the one that he contracted while in the hospital. She confirmed that at the time that Scott left the hospital on the morning of October 10th, a virtual visitation plan had in fact been set up at the hospital, whereby the care staff at the hospital would be able to keep in contact with the family via FaceTime, via telephone, to update them on Grace's progress and condition, to answer any questions. In fact, that was the case with basically all or most of the patients in the hospital. We heard that from plaintiff's own experts, even in their own hospital experience. It was routine that individuals, including individuals who had active POAs or individuals who were had developmental disability, often did not have someone at the bedside. Communication was routinely done. In fact, Dr. Verdine mentioned that he was not even allowed to be in the same room all the time. Communications on iPads, FaceTimes, telephones. This was standard, routine. This was happening during COVID, and that then is what was happening when Mr. Schara left the hospital. Mrs. Schara confirmed that her husband and she did receive multiple updates, multiple contacts from the nurse who was taking care of Grace that day. There were at least 3 of them. If there were any questions, they could certainly communicate at that time. She confirmed that her daughter Jessica was able to gain entrance to Grace's room the very next day. She confirmed that Jessica was able to communicate with her and with her husband freely. She was able to communicate via phone, via FaceTime. She confirmed that she and her husband did indeed deny every request from every caregiver who requested authorization from a ventilator. She confirmed that her husband Scott, in fact, had found information on certain media sites which led him to believe that it was ventilators, in fact, that people were not surviving being placed on the ventilators, and his conclusion was that it was ventilators that was killing people. And she confirmed for us also her belief that COVID was really nothing more than a simple. She confirmed her belief for us that she believed COVID deaths occurring in hospitals during the pandemic were actually being caused by the hospitals. Fair to state that Mrs. Schara did not trust modern medicine in October of 2021. Did hear from Mr. Schara. He confirmed a number of things as well. Following Grace's death, I'm a full-time activist and researcher. But as a result of the research that he did, he testified with regard to what he termed a worldwide agenda to implement population control through the agenda. He told us about his consent to admit Grace to the hospital, his agreement to stay with Grace and her consistent so while refusing to wear. He told us of witnessing a lengthy episode of agitation, and that was on the evening of October 7th, for which he explicitly gave permission to the nursing staff to administer a sedative in order to handle Grace's agitation. That was a testimony that we heard from Sam as well, where Grace was crashing in bed for about 2 hours. Scott was there, Scott Schara was there, and he witnessed that and certainly gave permission for that sedative agent. That sedative medication done under Dr. Marana's order. Mr. Schara conceded that he explicitly refused to permit Grace's physician to administer to Grace a medication known as tocilizumab, when it was offered. That was one of the COVID medications. He concedes that he had multiple conversations or mechanical support would become necessary at some point for Grace. This was being contemplated. On ventilators while he was in the hospital and determined that as a result of such research, he just did not want Grace intubated for Grace ventilator. And that occurred, and that continued throughout the entire time. Tried to back off a little bit on that claim here at trial, saying that he may have authorized intubation if only he'd known how sick Grace was. But the record says otherwise. Recall his letter to the hospital that was authored, and talked about it a little bit over on the stand. It was authored within 2 weeks of Grace's passing. And he indicated at that time to the hospital, he quoted, Grace needed a ventilator like she needed a Foley. Clearly within 2 weeks of Grace's passing, Mr. Schara did not believe that she needed a ventilator. No point would have agreed. Talk about being asked to leave the hospital on October 10th. Obviously, that was a big part of the discussions that we had with some of the experts as well. At least in part because he was shutting off or silencing certain alarms. He did that he had indeed been shutting off alarms or silencing Grace. He admitted that Grace herself was bothered by those alarms going off. He said prior to October 10th, he had deliberately disabled various alarms in the room without really knowing what those alarms were, and knowing they were not duplicate alarms. Concedes that he was indeed symptomatic with signs of a viral illness of some sort on the morning of October 10th. He concedes that he had in fact been formally diagnosed with COVID within a couple of days of being in the hospital. He concedes that he was indeed hospitalized 7 days after Grace's passing himself. In fact, he told us how sick he was during that hospitalization. He stated that there was a 50-50 chance he might not make it. That's how severe his case of COVID was. Mr. Schara confirmed that his daughter, Jessica, was admitted to the hospital on the 9th of October, the day after he died. Stated that Jessica, while she was at Grace's bedside, was able to maintain contact with him through the use of telephones, FaceTime, iPads, And this, of course, was consistent with standard practice that the experts in all hospitals was COVID. And people could not just gain entrance to the hospital as they had prior to COVID. Testified as to some of his closely held beliefs as relates to COVID. He noted, for example, his belief that the COVID-19 virus had never been isolated, would not concede that either he, white, or race actually suffers from COVID. It was, in fact, a pandemic, the deliberate result of a government agenda aimed at hastening death. In fact, testified his belief that St. Elizabeth Hospital, in providing care to Grace, was somehow operating as the arm of a larger group or a conspiracy aimed at ending the life of St. Elizabeth. Testified to his belief that the COVID vaccine is a bioweapon. He testified to his general distrust of medicine and of doctors in general. And he denied repeatedly on the stand that Grace was ever really sick at all in October of 2021. He was a little bit more forthcoming in that letter that we talked about, the one that was written about 2 weeks after Grace passed. He noted in that letter we talked about, based upon his review of the position, that it appeared to him within 2 weeks of Grace's death, reviewing those notes, that Grace was in fact losing the battle with COVID while she was hospitalized. Later in this courtroom, we're still making the case. Schara still making the case that Grace wasn't sick at all. You did hear from Jessica. Jessica was there at the time, the last several days with Grace in the hospital. She was not the POA at the time. She was, but we saw the POA back then. We looked a little bit at the wording of the POA, and actually there are individuals listed on the POA. But Cindy Schara was designated as the singular POA, and only if those agents or that agent is unwilling or unable to serve, is removed or is not available, only then are the people listed under its order. They become the. Well, there's been testimony that, of course, both Cindy and Scott were willing and able to serve. They've never been removed, and they were available at all times by iPad, by phone, and in fact, that's how communication was done. We know that. Dr. Schoenthal was able to talk to Scott over phone and over the iPad. So the decision maker was in fact Cindy, and when she deferred to Scott, the decision maker was Scott. But Scott Schara and Cindy Schara were always the decision makers, and Jessica never became the decision maker because they're not all. Everyone on this document is not the decision maker in the order in which they're listed. And as long as decision maker 1 and 2 can serve, they're the decision maker. We want to clear that up. When we talk about POAs, we don't want to talk about that because the decision makers here were Mr. and Mrs. Schara. Certainly Jessica was her sister and was in the hospital with her and was with Grace, but she was not the designated decision maker. The people who were being talked to, the people who were giving informed consent, those were Grace's. Now, Jessica did concede that during the 3 days she was with Grace, she was in the hospital. She observed doctors, nurses, other medical personnel coming in and out of the room many times. She conceded that she did in fact wear PPE while she was in Grace's room at the request of the hospital. She had testified this was one of the things the hospital had requested of her in order for her to come into the room. In fact, that was one of the issues and why the hospital wanted to negotiate, to talk to Mr. Schara's representative before Grace or before Jessica was allowed into the hospital, because Mr. Schara had just contracted a very severe case of COVID while being in that. It was important that the hospital understand and everyone involved understand what the dangers were of being in that. Eventually, Jessica was allowed to come to the room because she understood the danger. She agreed to wear PPE, and not uncoincidentally, it doesn't appear that she was at the There's a cause and effect there. She was very PPE. Ms. Vander Hayden conceded that while she was present in the hospital, she personally observed the nursing staff, for example, feeding Grace on a number of occasions. This could sometimes be a difficult process because she was so dependent on the BiPAP that was the testimony. The BiPAP mask would be removed slightly, and some feeding would have to be done with a protein shake or something of that nature, and the mask would have to be put in place immediately back on because she had difficulty breathing on her own. She would immediately desaturated. She was so dependent on that BiPAP that she couldn't just sit down with a tray of food in front of her and just eat. This was a problem. There was always an aspiration risk because when we have this forced air BiPAP device, you can't just eat with that on there. It can blow the food particles down the long tube essentially into your esophagus and your airway, and that is very problematic. Nonetheless, feeding was being attempted. They were doing that, and she observed that first of all. She conceded Grace was BiPAP dependent the entire time she was with Grace. We talked about the BiPAP. That's the mechanical breathing apparatus that was upon which Grace was entirely dependent throughout the hospital stay. Needs that Holly, when Holly was in the 12th and the 13th, talked to her and explained that the oxygen monitors were showing that Grace was in fact taking an abnormally large number of breaths. She conceded that she observed Holly helping Grace to eat, providing various nursing cares throughout her 2 days. She concedes that she was never prevented from asking any questions of the nursing staff while present. She concedes that whenever she had questions of the nursing staff, and that would be Holly, since Holly was in the room, the nurses would always attempt to answer those questions for her. She conceded the nurses explained to her what all of the machines were doing in Grace's room. This was even on the 11th. She even recalled seeing a machine at Grace's bedside that was labeled Precedex. She testified that the nurses explained to her that Precedex was an anxiety medication. She concedes that she was able to stay in contact with her father by telephone at all times while she was in prison. She concedes that no one prevented her from contacting her parents whenever she needed whenever her parents had a question. She was fully able to get a hold of them, and they were able to get a hold of her. And she also admits that it was her understanding at all times that while Grace was in the hospital, her parents did not want Grace ventilated. She concedes that even at the point where Grace was arresting on the evening of October 13th, she understood that no resuscitative efforts were consented by her parents that would involve intubation or mechanical ventilation. Finally, remember that letter that she wrote at the time about when Grace was in the hospital, written, she said, about 2 weeks after Grace. What did we learn from that letter? Well, she did write in that letter that she chose to stay overnight with Grace on the evening of October 12th to the 13th because her parents had informed her on the 12th that the doctors were not giving them much hope. The doctors had told her parents as of the 12th that Grace's lungs were showing more scar tissue, not able to maintain her oxygen. The doctors had told her parents by the 12th that Grace could really go downhill fast. She could not keep up with good oxygenation level. She was also in the room when Dr. Schara and Holly were at Grace's bedside, and when the Precedex was shut off at the bedside. She said in that letter she witnessed this. She saw when that medication was on the bedside. Holly and Dr. Schara also testified to that as well. But the third person in the room was Jessica. There's another direct quotation of note from Ms. Vander Heiden's letter, and that concerns specifically the time when Grace was coding at the time. And if you recall what that quote was, she mentioned, and I quote, Grace was gone within minutes, actually seconds. Why is this important? Well, it tells us that Grace's code went fast. She was gone in seconds. Records back it up. Can we put up exhibit 444? told us about why some of the things that we're seeing here are not consistent with an overdose. But it also tells us how Grace was doing in the minutes prior to her ultimate passing. The more the death certificate. We also see there the rest. Normal for us breathing here today, for me breathing here today, it's about 12 to 20. She was at 45 minutes after administration of the morphine, she was breathing at roughly 36, and then she's above normal all the way until about 1920, and then we get to 2 minutes before her ultimate passing, and she's at 14. That's a normal rate of breath for you and I, as we sit here today. 2 minutes before she passed. There's been testimony that she didn't have a blood pressure. They're giving medication for someone who doesn't have a blood pressure. That's not true. We'll talk about that. She had a heart rate. She had a normal heart rate. She was breathing faster than normal the entire time that we're talking here. We don't see an appreciable drop in these numbers, and she's still at a respiratory rate that's normal, essentially, for you and I sitting on blue air, 2 minutes before she passed. That event went fast. We're not talking about a lengthy period of time. It was a matter of minutes, actually seconds. Now, we heard from some experts. We heard from Dr. Burdine. Dr. Burdine told us a number of things. He was initially contacted to serve as an expert for the Scharas because he was part of an email or a text group, however he described it. It was called C21X, and he described it as a group of people who were disagreed with the official narrative on matters related to COVID. It was a group of people who maybe included individuals who disagreed with the official position taken on maybe vaccines or on the official narrative of the vaccines or on hospital protocol. The COVID pandemic, there were patients who, despite receiving treatment that complied with the standard of care, did in fact still pass away as a result of COVID. Conceded that the COVID virus created a great deal of illness, and indeed it caused. He testified to the mechanism of how COVID pneumonia affects the lungs, how it causes acute respiratory distress syndrome, or ARDS, ARDS. He testified that the hospital in which he worked in 2021 at Texas Tech University routinely utilized ventilators in the treatment of COVID patients. He testified that ventilators did indeed play a role in the throughout the nation in 2020 and 2021. He even told us about alarms in the night. Alarms that help the healthcare provider, specifically the stay on top of a patient so that they don't miss any important information changes. Also told us that as a private hospital, St. Elizabeth Hospital did have the right to determine through policy who was permitted upon the premises and who was not. He conceded that CDC guidance in 2021 required that persons who were symptomatic would stay home and not go to the hospital until return criteria were met. He testified that personally own hospital who did not have visitors present in the room with them. He conceded that in caring for COVID patients at his own hospital, when it was frequently necessary for him to communicate with family members remotely, similar to some of the times that we were talking about here. He concedes that in such situations, he believes he was able to adequately and accurately communicate with the family members using these even though they were not present, testified that he believed he was able to adequately and appropriately communicate to family members and patients via telemedicine. And he concedes that according to the records of this case, there was indeed a process set up in the hospital between Mr. Schara and the hospital on October 10th before he left the hospital for the nursing staff and doctors to be able to communicate with him and with his wife, the decision makers, via iPad and FaceTime. He concedes that there was no point in time where Jessica did not in fact have open and free access to communication with both her mother and her father via FaceTime or iPad messaging. I want you to think hard about the next couple of points brought up, because I think they're very telling. I think they're important for us. Dr. Verdine also concedes that as a consulting pulmonologist, he did not use precedents. He said during the course of his own practice as a pulmonologist, he had never had an informed consent conversation with a patient or a patient family member. He concedes that he has never prescribed the medication. He concedes that he has never titrated or administered the medication. He's the only one in this case that Grace overdosed on precedents, and he has never, in years of practice, administered that medication. I'd like you to let that marinate. It's important when you come back. Vital signs. Now, what did Dr. Verdine tell us about vital signs? You can see that a patient's inability to maintain an oxygen saturation above 90% as a pulmonologist. He testified that as a pulmonologist, a respiratory rate of 30 breaths per minute or higher would be of concern to him, because that's a respiratory rate that shows severe hypoxemia. He testified he would have concerns that there would be an emergency condition if a patient's respiratory rate were above 50, because that would be a severe hypoxemia. He testified that he would have concern as a pulmonologist with any patient exhibiting a respiratory rate above 50 in combination with an SpO2 or an oxygenation rate below 60. Dr. Verdine, however, seemed oddly ignorant in his trial testimony that these concerning vital signs that he discussed with me actually described Grace's condition exactly on October 13, 2021, as COVID ravaged her lungs and eventually life. Susan Eichinger, you heard from her. She's an expert in the plaintiff as well. She's one of two experts. Nurse Eichinger noted, for example, her experience as an ICU nurse treating COVID patients limited 3 months that she spent working in a COVID at her Cape Canaveral hospital between August and October of 2021. Recall also that Nurse Eichinger told us that she quit that position a week or so after she concluded her 2-month stretch in that COVID ICU at that time. Due to the stress toll taken on her in that COVID ICU for those 2 months. By October of 2021, Nurse Holly McGinnis had been caring continuously for COVID-19 patients for 19 consecutive months. The pandemic began in March of 2020, and the care of Grace occurred in October of 2021. Nurse Eichinger concedes that based upon her review of the records in this case, Grace Schara was indeed while she was in the hospital at St. Elizabeth. She concedes that visitation restriction policies were global in hospital countries. She concedes that while she herself was treating patients in the COVID at her hospital in October of 2021, she routinely communicated by telephone with the ICU. She concedes that whether a patient had an activated POA or not, the only way for her to speak to family members or POAs if necessary was to talk by a phone. She feels she was able to comply with the nursing standard of care at all times when she was operating under the nursing. She conceded that most of the patients for whom she cared in the COVID ICU unit in her own hospital were actually intubated, somewhere on the order of 95 or so. Indeed, were intubated. She concedes that Precedex was used on the COVID ICU unit at that National Hospital in order to treat both restlessness and agitation as of October of 2021. She also concedes, and this is relevant, that in her entire career as a nurse, she had never, on even one occasion, titrated the medication Precedex for a patient. She concedes that she cannot say that Mr. Schara was turning off only unnecessary alarms prior to being asked to leave the hospital on the 25th. She agrees fully, as a nurse in an ICU should, that alarms are important to ICU nurses, being able to assess patients, knowing conditions. She concedes that she could point to no evidence in the record that Grace's sleep was ever affected by any alarm or ice. And she concedes that there's no evidence that Scott Schara's absence from Grace's hospital room after October 10th precluded the nursing staff from effectively proning Grace when they needed to do so. Testified there's no evidence in the record to suggest that Jessica was in fact inhibited in any way from freely contacting parents via remote means while she was in the hospital. And she concedes that there was nothing in the record to support a contention that Jessica did not in fact have the ability to ask whatever questions she had and to be able to contact and speak with Grace's providers and her parents while she was in the hospital. Now, we also heard from a number of nurses who worked at the hospital. The first of those was Nurse Emily Fisher. You may recall Nurse Fisher. She personally observed Mr. Schara interfering with some pump alarms in Grace's room. She noted in her nursing note of October 10th that Scott Schara had in fact demanded of her that she turn off all IV alarms completely in Grace's room. She testified that Mr. Schara had demanded that Grace's SpO2 or oxygenation device. She testified how dangerous that would be. In fact, we heard that testimony from the nursing expert, Nurse Davis, as well. How dangerous it is to acquiesce. Turn them all off. Turn all of them. No expert told us that it would be appropriate to just turn off all of the ICU. ICU patients are sick. Those alarms are there for a reason. Every person who's been asked about alarms in an ICU, every expert has testified, they're there for a reason. You can't just turn. She could not comply with that, and her notes indicate that she attempted to explain that. She explained it several times. She attempted to. Now, she also testified that she personally observed that Mr. Schara was visibly ill then. It's something that becomes have a conversation with Nurse Bartholtz, and she was one of several people who actually visibly were able to tell that Mr. Schara was suffering from a viral illness that morning. One interesting point, Emily, you'll recall, gained some brief renown in this case when she elicited the shortest cross-examination of the trial. The cross-examination consisted essentially of plaintiff's counsel attorney Mendenhall posing a single question to her, angrily. What did anything you just testified to here have to do with racism? What did anything you just testified to here have to do with racism? That was the extent of the cross-examination of this witness. And I can tell you, Emily was called to testify about what she did talk about, the background facts underlying Mr. Schara. For once, I completely agree with Mr. Mendenhall. What exactly did Mr. Schara's removal from the hospital in October 10th of 2021 have to do with racist death? Nothing. In that cross-examination question, the shortest one of the trial, Mr. Mendenhall inadvertently said the quiet part out loud. What did the removal of Mr. Schara from the hospital do? How did it contribute in any way to racism? We heard from Allison Bartholtz, who's the charge nurse. We heard that she was the one who actually asked Mr. Schara to meet that morning. She testified. She had a calm conversation with him that lasted somewhere between 4 and 5 minutes that morning. She asked him to leave the hospital specifically because he was exhibiting severe symptoms of COVID. She described cough, weakness, inability to speak in complete sentences because needing to stop and catch his breath as he talked. She recognized these were all symptoms of a severe COVID infection. She was worried that Mr. Schara would decompensate completely right there in the room, and then she'd have 2 severely ill COVID patients to care for instead of just 1 in a full ICU. She testified she also asked him to leave because he had been interfering with some of the alarms braces, including pump alarms and oxygen monitors. She testified that silencing an oxygen monitor in Grace's room would silence that monitor for up to 5 minutes, not only in Grace's room, but also at the nursing station. And this would be completely unknown to Grace's therapist. So one of the reasons Grace was in the hospital to begin with was to have her oxygen monitored supplement. Silencing the alarms of an oxygen monitor in Grace's case could have been deadly. She testified she was concerned for Schara's safety, as well as the safety of Grace when she asked him to do that. She testified, in fact, that she didn't make the decision on her own either. She, in fact, consulted the hospital administrator that was there at the time on that Sunday, and then she consulted her own nurse manager before she approached Mr. Schara and asked him to leave. She also testified she followed hospital policy in conversing with him and asking him to leave that day. She testified that she did explain the visitation policy to Mr. Schara, and she also confirmed that she bore no ill will toward Mr. Schara and that he left the hospital that morning without confrontation. Testified that she did indeed offer virtual visitation to the Scharas, and in fact, she voted in the vote. Saw that when she testified. And Mr. Schara left the hospital on the 10th. There was a visitation plan that was set up. In fact, we saw later on that Mr. Schara and his wife had multiple conversations remotely with, I believe, the nurse was Catherine Hale. She was the nurse who was taking over Grace's care on the morning of the 10th. Sam Haynes, we've heard his name several times. In fact, we saw his face several times because he was called in the defense case, and he was called back during the defense case. He was the ICU nurse who actually commenced the precedent titration on the 7th. That was when Grace was having this period of great agitation where Sam noted that she was thrashing around in bed for hours. This was also the time when Mr. Schara admitted that in order to help get on top of that, he authorized the use of the precedent for the first time. That's when Dr. Murata put that order in for the precedent. Now, Sam Haynes testified that he began the titration at 1.0 micrograms per kilogram, as was required by the order of the ordering physician, Dr. Murata, before he then turned the titration down back to about 0.7 micrograms about 20 minutes later. He testified that the reduction of that initial titration rate down to 0.7 was not at all unexpected. It didn't constitute an overdose at all. This was a man who's done this before. And it's important to realize that when he did that, it was at the beginning of the titration. Doctor put titration parameters in, you can titrate between 0.1 and 1.5, start at 1.0. Doctor's order is to start at 1.0. We need a starting point. We have to start somewhere. Started at 1.0. That's where his nursing, clinician skills get in. His job as the nurse is to implement the doctor's orders and then to see what needs to be done in order to titrate that medication for clinical appropriateness according to what you see. He had a RASS scale, R-A-S-S, we heard about that. He had a target under Dr. Murata's of -1. Saw that RASS scale, but it explained what a RASS scale was. So he was aiming for a certain level, and then he was observing what would happen at that level. Well, at a level of 1.0, he noted that the sedation was a little bit more than what he wanted on the -1. He said -1 on that scale. We could put up 442. Now, we saw this before. This is the RAS score. And this tells us what each of those scores means from +4 to -5. We'll recall that on the Precedex administration record, at the time that Nurse Haynes changed the prescription or changed the titration from 1.0 to 0.7, he made a note that he was seeing a RAS score of -3. When we look at that, what is -3? It's moderate sedation. Movement, your eye opening, voice, no eye contact. Moderate sedation. Dr. Burdine, who knows nothing about Precedex, that he didn't read off of the package insert, called this, as I recall, a catastrophe. A RAS score of -3 put her into a category of moderate sedation. But to Dr. Burdine, that was a catastrophe. Now, Nurse Haynes testified that certain common medications, including atropine and norepinephrine, are commonly used in the ICU in order to manage and mediate a patient's blood pressure for any number of reasons. He testified that nothing which occurred on either October 7th or October 8th was indicative of an overdose of Precedex as they use it in the ICU. Nor did anything that occurred on either of those 2 days constitute a life-threatening or even unusual event. The side effects of Precedex were known and were routinely monitored. Precedex is given because it is a needed medication. It stays on top of the agitation. The key metric here is getting enough oxygen to that patient to maintain the life and get better. In order to do that, sometimes they need to be prone, sometimes they need to wear a BiPAP mask, sometimes they will not survive without these modalities. Getting that oxygen is the #1 issue. We need to keep these patients oxygenated. We need these sedative or anti-anxiety agents in order to help us do that. We need to give these medications. All medications have side effects. We've seen that. We've seen the package insert ad nauseum about the side effects. Side effects were recognized. They were known. They are given, these medications are given in the ICU so that the patient can be assessed and constant watch made over. That's exactly what happened here. The known side effect occurred, it was immediately addressed, and nothing else happened. It was not an unusual event. There was, in fact, nothing that needed to be or was required to be communicated because this was standard general ICU care in the management of these medications. If the plaintiffs had called any who had any experience actually titrating this medication, using this medication, they would know that. Heard the testimony from the people who have actually been doing it. Sam Hayes actually did it. McGinnis actually does it. She uses it. Titrates it. She knows the RAS score. She knows what she's doing. She told me. We heard from Nicholas Sylvia. Recall Nicholas Sylvia. He was the director of pharmacy for St. Elizabeth Hospital. Now, he told us that Precedex, lorazepam, and morphine, the medications, were actually frequently used in the ICU at the hospital and frequently used in combination. He explained how medication orders were captured in the medical record in Meditex in 2020. He explained Meditex, he called it a decision support function, and it automatically checked potential drug interactions from any medications that were ordered. He testified further to the role of an additional pharmacist who was assigned specifically to review medication profiles in the ICU at St. Elizabeth Hospital as an added check against potential adverse drug interactions. He testified that the Precedex order for Grace in this case would not have tripped any red flags with his pharmacist. He testified that the standing order for lorazepam at 0.5 milligrams would not have tripped any red flags with his pharmacist. He testified that Dr. Shokar's verbal order for morphine on October 13th of 2021, a 2 milligram dose, would not have tripped any red flags for his pharmacist. Holly McGinnis has been with us throughout the course of this trial. She testified on several occasions. Testified extensively, in fact, just a couple of days ago. She explained the care that she rendered to Grace and the amount of time she spent with Grace. She's been an ICU nurse for nearly 20 years. And if we're talking about someone who knows Precedex and has administered it to patients, to hundreds She's the one. She's the one person we've heard the entire trial who would know precedent. She confirmed that Precedex, lorazepam, and morphine were common medications frequently used singly and in combination in the ICU. Something that any clinician who actually took care of patients and actually monitored patients in the ICU. She testified that medications like atropine, norepinephrine were frequently in common use in the ICU in October of 2021 to help the nursing staff manage patient blood pressure for any number of conditions. ICU patients are sick. They frequently must have their blood pressure monitored and managed. She explained that there was no adverse event involving Precedex in Grace's case on October 7th or October 8th, as Grace's blood pressure was being assessed and managed in a routine and effective manner at all times with the medication she was being given. She also took us through in painstaking detail each of her narrative nursing and the vital signs that she was recording while she was bedside with Grace on the 13th. We looked at those and we had a little discussion of those exhibits. In fact, we put them on these demonstrative exhibits, right? You might remember this chart that we have that shows Grace Schara's vital signs on that last day, from about midnight until about 6:37 when she was there. And we can see here, because it also has all of the times when the Precedex and the other medications were given, we could see what the key vital signs are here: the pulse, the respiration rates, and the SpO2. She took us through each of these things, and we talked about those. And if you recall, we saw even when all of these things were being done, and we do see the Precedex was titrated several times. And why was that? Well, she explained to us because in the morning when she came on, she was attempting to prone Grace. Grace's oxygenation was very low. Proning was one way to get that oxygenation up. We needed that. But she was not able to prone. She was too agitated to prone. Precedex was, in fact, one of the ways in which we could achieve that proning. That's why it was done, because you're titrating to effect. Can she now do this? Can we have her prone? You have to give her the Precedex to get that therapeutic modality. We're not titrating to a number, 0.7. Anything over 0.7 is an overdose. We're titrating to a therapeutic effect. Someone who titrates this medication on a regular basis would know that, which is precisely why Dr. Verdine did not know that. We also see the key points here, because after the Precedex is given, and recall, when we were going through these notes and we were pointing out all of these numbers on this chart, we were also looking at the actual entries themselves, and we could see in entry after entry the RAS score was right. The RAS score was indicated, and in virtually all of those RAS scores that we saw, she was right at about -1. There's a couple where she was at 0, a little higher. But even with Precedex running at these levels, at 1.2 and then later at 1.4, we saw the RAS scale at that time. When all of these numbers were showing here, the RAS score was at the target that Dr. Murata included in his original Precedex order, -1. She's titrating to the effect of -1. She's titrating to that. We want drowsy. We're looking for drowsy, -1. That's what she was getting when she was giving these medications. That's what Grace was when she was receiving these medications. It's been represented to you that, oh, she's receiving way more Precedex than she was back on the 7th. That's right, because we're not titrating the number. We're not titrating to 0.7 as Dr. Verdine would have us. We are titrating to drowsy, and that's exactly what Nurse McGinnis did. There's also some testimony that we've heard about restraints on the morning of the 13th. Nurse McGinnis was very honest. She recalls utilizing a non-restraint modality called MITS at some point, and that was to help keep the patient from inadvertently ripping that mask off and didn't really act. She didn't recall specifically from 4 years ago whether restraints were used at any particular time. We do know from the record that restraints were used for a small period of time back on the evening of the 7th when Grace was first going through this really original period of agitation. And we know that Mr. Schara was actually on board with that. Restraints are used only in certain situations, and Nurse McGinnis told us what that is. Only to avoid inadvertent interference with a medical device, like a bypass. You do that when you're agitated, you're gasping for breath, when you're not getting enough oxygen to get agitated. It's like drowning. So you're ripping and you're pulling. As restraints are sometimes used in those instances, it would not at all be unusual that a restraint might be used for a short period of time in those instances, because once again, we're trying to keep her oxygenated. The number one goal here, above anything else, we need to get her oxygen. We have to keep that mask on her. We have to prone her. This is what the nurses are doing. This is the number one role of the nurse. Have to keep her oxygen up. If restraints were being used, it's for that purpose. And in fact, the use of Precedex is for that very purpose. The use of Precedex is to achieve a level of drowsing, a level of sedation, so that things like restraints are not used. You don't need them when you're properly under just the right titration level of anti-anxiety medication. That's why we're seeing this here. We're trying not to have to use restraints. We're trying to get her oxygen. That's what Nurse McGinnis is. We also heard some testimony from Nurse McGinnis when she was on the stand there. And we heard a little bit today, too, about having no blood pressure. There was never a point where Grace had no blood pressure. Nurse McGinnis did explain in the record there was a point where the blood pressure would not be detected by the cuff, but it's a cuff. You have to try it a couple of times. Sometimes the cuff is not reading, so you have to unwrap it, flip it over again, and do it again. She did have a blood pressure. There was a notation that the cuff was not reading a blood pressure at one point in time, but we see these numbers here. She had a pulse. In fact, she had a normal pulse throughout all of this time that we're talking about. She had an oxygenation rate. She had a respiration rate. She was not pulseless. She was not without a blood pressure. If she was without a blood pressure, she would not have these numbers. We also saw these numbers. Nurse McGinnis explained what these numbers were and what they meant to us. And she explained in very great detail what these are telling her. These are very bad numbers. They tell us a big story about exactly what's happening with Grace's lungs at that time. These respiration rates are very, very high. By the time we get down to noon, we're into the 50s, the 40s and into the 50s. And they continue then throughout the rest of the day. We have normal pulses. She's got normal pulses, but her respiration rates are off the charts by the evening of that day. Her oxygen levels are very, very low. Recall Dr. Burdine told us that he, as a pulmonologist, would be very concerned about this combination of things that we're seeing there. But this is what they were attempting to manage, and this is what they were attempting to manage without the possibility of being able to utilize a ventilator. We also see where the lorazepam was given, and we also see that the actual vital signs don't budge. In fact, they're actually respiration and SpO2 are going up a little bit, but the pulse barely budges. These two medications are given, and 20 minutes later, her vital signs have not budged. Remember, it's being argued to you that she overdosed, at least in part, as a result of these lorazepam administrations. But the actual records, they show that her vitals did not budge. These two medications had no effect. That's why that's why Dr. Schara is important, because he's seeing this and he's seeing clinically there is no effect. The clinical numbers on black and white on the paper show those lorazepam doses did nothing to move the needle with her vital signs. Did we see this from Dr. Burdine? Did Dr. Burdine show us any of these? Did we see anything about these vital signs from Dr. Burdine? We did not. Vital signs are Dr. Burdine's kryptonite, ladies and gentlemen. They disprove his theory. This shows how sick Grace's lungs were, and Dr. Burdine doesn't want to talk about her sick lungs, which is a little disappointing coming from us. We talked about a little bit, but we heard some testimony indeed from Dr. Bruce Goldberger. He was the toxicologist, and we've heard a lot about Dr. Goldberger's his definition of overdose. But interesting, what we haven't heard during the administrator's opening was the actual opinions that Dr. Goldberger offered. He told us that the dose and frequency of these medications, Precedex, lorazepam, and morphine, were appropriate. The doses that Grace received were consistent or were inconsistent with any allegations. This man's entire professional life is dedicated to the study of medication interactions. routine and appropriate. The administration of Precedex, lorazepam, and morphine to Grace Schara did not contribute or cause in any way to death. And the plaintiff has not produced a toxicologist to tell us the difference. Heard from David Fisk. Dr. Fisk is an infectious disease doctor. He told us essentially that Grace's case history is highly consistent with severe COVID-19 leading to decline and demise, something he saw over and over in his treatment of both patients. He told us the time sequence of her illness was consistent with severe COVID disease, the Delta variant at that time. He talked about Grace's COVID-19 testing. She was positive. Those tests are very accurate. He talked about Grace's symptoms, fever, cough, shortness of breath, confusion, all consistent with severe COVID. Worsening pneumonia, we saw throughout the time on the chest X-rays that we received. He looked at those as well as Dr. Wittstock. He talked about Grace's labs. Remember that D-dimer? He talked about the D-dimer. He saw a 10-fold increase of the D-dimer rate. He said that he'd never seen that. Infectious disease doctors had never seen such a massive D-dimer rise until he saw COVID, and then it became flag, a signal flag for severe COVID. They started to see massive jumps in D-dimer, and he saw that in his record. Put the record up and showed me that massive 10-fold rise in D-dimer. He also talked about the respiratory failure leading to her inability to adequately oxygen. Testified to standard COVID-19 treatments, dexamethasone, tocilizumab, remdesivir. He noted that the medications received by Grace in this case were indeed routinely used in the treatment of COVID-19 patients back in critical care settings in 2021. He talked about typical adult ICU medication dosing practices. For example, referred for us that the standard of care does not require a doctor to discuss every modification or every medication that's given routinely to a patient in the hospital once a patient is in the hospital. He explained the role of mechanical ventilators. He identified the likely triggers for Grace's agitation, which were multifactorial. Just having COVID-19, experiencing respiratory failure, having a fever, having low oxygen levels in the blood. These are all things that cause agitation. He recapped hospital visitation policies as they existed, as he was seeing them back in 2021. And he also explained to us at that point that at the point of Grace's cardiac arrest, her chances of survival approached zero, even if CPR. Whether CPR were performed or whether some sort of medication reversal agent were given, mechanical ventilation was necessary, and that was not a modality that was in the toolbox. Met the standard of care. They met the standard of care relative to medication administration. In fact, no expert really has indicated that nurses failed to meet the standard of care relative to actual medication. In all cases, the nursing staff followed proper orders from the doctors, and there's no one who indicated that that was improper or that proper orders were not followed. She testified about the integration of family into the care plan. She talked about the importance of alarms in the ICU room. She talked about Mr. Schara's own COVID symptoms and the reasons why he was removed from her room. She also noted and gave instances of how Grace was well supported by the staff and how communications between Grace and her decision makers continued. She also talked a little bit about resuscitation guidelines, and she explained as well that you don't have the ability to intubate, you can't aid circulation without oxygenation. It's futile. It's futile to be able to resuscitate. You can't resuscitate someone. You can't get oxygenated while moving. You can't do that. Now, we heard testimony as well from Dr. Binstock, Dr. Garibaldi, Dr. Beach. Recap their testimony in more detail, but I will say that Dr. Binstock, his description of the X-ray imaging for Grace during her hospitalization was quite compelling. In fact, we saw some of the images that he was looking at, both with and without an overlay. And he looked at all of these and took us through these things, what these look like. And they're all there, all of the images that were placed. He went through one by one and showed us all of these X-ray images are bad, from the 6th to the 13th. They show severe and advancing COVID, and it's getting worse as we're going. The findings on these X-rays, notably, cannot reasonably be explained by a medication overdose. We are seeing clinical situations right here on these versions in these X-ray studies that show us, indeed, advancing COVID disease. None of this can be explained by any medication that's used. Dr. Garibaldi's opinions are also medically compelling. You'll recall he testified that Precedex is a medication that was indeed routinely used in the ICU. The administration of medication by the nurse staff in these cases fully within staff. That was one. He told us race did not experience it. Administered to her were common, routinely used, and were always given within the parameters that the doctors gave them. He testified that Mr. Schara's removal from the hospital on October 3rd did not. He testified that the resuscitation of Grace following her arrest on October 13th would have been futile in the absence of intubation and mechanical ventilation. Again, come back to that. Only mechanical ventilation would have had the potential to save her life at that time. The cause of her death was COVID-19, and Dr. Garibaldi explained that in great detail. Recall that he was, in fact, during the COVID-19 pandemic, with the one of the top institutions that was dealing with COVID infection. He had very deep knowledge of the issues that were going on. Ladies and gentlemen, I'm going to ask you to do a little reading between the lines as well. First thing I want you to do. Plaintiffs have two experts. They have a pulmonologist, Dr. Burdine, and they have a nurse. Why only two? Why only two experts? Why no radiologists? Why no infectious disease experts? Why no toxicologists? Why no pharmacists? Plaintiff claims that Grace's death was caused by a medication overdose, so why no pharmacist or toxicologist? These would seem to be useful experts when we're talking about potential medication overdose, yet plaintiff relies solely upon a lung doctor, Dr. Burdine, for an opinion on essentially everything. The answer, I think, is fairly obvious. Plaintiff could not find a pharmacist or a toxicologist who would be willing to risk his or her credibility in order to support plaintiff's red bear overdose. We heard from testified at the behest of the defense. Both that defense toxicologist and the hospital director of pharmacy confirmed these two medications would be used together. The dosages were too small to cause an overdose. Grace's vital signs on the 13th were completely inconsistent with the overdose theory. We saw that. Recall the testimony was that if you're going to have an overdose, you're going to start seeing a respiration in 5, 6. Normal was 12 to 20. You're going to see respirations below that. We're seeing respirations completely the opposite direction, completely the opposite the entire day of the 13th of what we would expect to see with overdose. If plaintiffs had been able to find an expert in toxicology or a pharmacist who was willing to support this overdose theory, you can be sure you would have heard from them. And that's telling. I ask you to read between the lines as well, because neither of the experts that the plaintiff does have has any experience prescribing or titrating precedents. Yet plaintiff's main argument in this case appears to pivot upon a theory of a Precedex overdose. One would imagine that you would want to call an expert who has at least a tiny bit of actual hands-on experience titrating and administrating the medication upon which your entire theory revolves. Dr. Burdine admittedly does not titrate Precedex, does not prescribe Precedex, knows nothing about Precedex beyond what he read in a package insert. Now, ladies and gentlemen, my 18-year-old son could read a package insert. I love the boy, but I would not trust him to take care of me in the ICU. Having an MD next to your name does not make Dr. Burdine an expert on Precedex, and yet he is the sole expert you heard who criticizes the use of Precedex in this case. Essentially, Nurse McGinnis, Nurse Haynes, Nurse Fisher, Nurse Davis, they've titrated and administered more Precedex on any given Tuesday of any given week than plaintiff's two experts have done in their entire respective career careers combined. No one who has any experience actually administering or titrating Precedex would support plaintiff's overdose. Anyone who actually had personal hands-on experience with the titration of this medication would know that Dr. Verdine's opinions are simply not consistent with the way this medication is. Dr. Verdine insists that the titration of up to any number above 0.7 necessarily is the equivalent of an overdose, but that opinion is entirely without foundation and betrays a distressing level of ignorance. Heard about the concept of titration to effect. The nurse actually titrating Precedex aims for a therapeutic effect, not for a mere number on a page. We saw that when we looked here. The RAS scale, the titration to effect, is exactly what we were seeing when we were getting when we were looking at this. Even though she was running at 1.2, 1.4 Precedex, we were still achieving that target of -1 RAS score at the time. We're titrating to effect. Plaintiff claims that Grace died as a result of a medication overdose, yet the plaintiff's nursing expert holds no opinion on the administration of any of these medications either. Again, I think the reason for this is obvious. No ICU nurse who's actually used or titrated Precedex could support plaintiff's overdose. If plaintiff could have found an ICU nurse who would be willing to offer support for an overdose theory, you can be sure we would have heard. We also heard a little bit about Dr. Verdine and his theories. Saw him up there on the screen talking about metabolic acidosis, things like that. You'll recall that it came up that during his testimony that theory actually came up for the first time in his rebuttal report, his third report, he had 3 reports, and a rebuttal report that was issued after the defense expert issued the report. Dr. Verdine saw the expert reports produced by the defense experts, knew that his original overdose theory, his first 2 reports, was not going to fly, so he cooked up the present metabolic acidosis theory in a desperate attempt to explain Grace's elevated respiratory rate without having to concede that the elevated respiratory rate that we're seeing on this chart here was due to lung damage. He can't admit that. Because if he does, he'll have to admit that he's death, and he's not going to do that. Dr. Garibaldi, Dr. Fisk, Dr. Shokar, they've all conclusively refuted Dr. Verdine's metabolic acidosis theory. Ask yourself, why did it take Dr. Verdine so long to develop this theory? He had Grace's medical records for over a year. He drafted 2 lengthy reports before he ever stumbled on his metabolic acidosis theory. Dr. Verdine even testified that any competent physician would have recognized this metabolic acidosis, yet he didn't stumble upon the theory until very late in the game after he got the defense expert reports. This would make Dr. Verdine either incompetent or. Let's also ask about why these 2 particular experts. Both were hired based on their appearance or their participation in social media or chat groups. Both plaintiff's experts have access to Ryan in terms of the narrative surrounding COVID. Dr. Verdine was targeted by the plaintiff as an expert whose participation in a chat group designed to disagree with the existing narrative surrounding COVID. Nurse Eichinger also had some strong feelings relative to the narrative of COVID. We put up exhibit number 6.
How much longer do you have? Okay, so we'll take our break right now. It'll be, maybe don't want to call anybody out, just by a shaking of a head, would you like the 20-minute break or something quicker than that? Okay, so we'll do our 20-minute break, and then we'll come back in and make the next steps in these closing arguments. The jury is excused. All right, this is a hearing outside the presence of the jury, 11:45, sound good? Yep. Well, good question. I was thinking maybe like 1 o'clock. I don't know how long are you gonna have, Attorney Guzzi?
Well, given the territory that Attorney Frank Koyak has covered, I think I will be able to shorten mine up a little bit. I was thought, what?
Just a little bit?
I think it was clocking in at about 45, so it should be less than 45.
10?
Okay, so what we'll do is just probably go that hour and a half, we'll take a lunch at the end of all of it.
And then can start deliberating at that.
Yes, so we'll be back at 11:45 and the plan will be to finish all of it. Thank you, we're adjourned. All right, everyone may be seated. Welcome back, members of the jury. I think you were told, so I'm just going to tell the lawyers because I base it on their timeline, but your lunch is going to be here at about 12:45 or 12:50. So I expect they'll want you to get it when it's warm. So we'll go until they're finished, but that's going to be about the timeline, 1 o'clock-ish or so. Attorney Frankowiak.
We're talking about reading between the lines. Another area like reading between the lines. Plaintiff's exhibits united focus on the testimony of experts were notably light on substantive notes for Grace's medical records as well as vital signs. Both Nurse Eichinger and Dr. Verdine issued reports that gave trial testimony that were both very light on reference to the actual provider, actual reference to vital signs. Mr. Schara testified, if you recall, with review of the medical records, counted about 22 different provider notes. This is Schara. Very a number of those provider notes have been marked for this one. Provider notes of Grace's charges reveal that all of Grace's treatments were essentially unanimous, recognizing that Grace suffered from diseases. Vital signs are problematic. Clearly make it very abstract high proximity. The vital signs are fully consistent with COVID-19, completely inconsistent with an overdose theory. You see that, for example, as we talked about on this board right here. Grace's pulse, heart rate are essentially normal throughout the 13th as we're talking about this. But the 2 doses of lorazepam don't move the needle in any way. We would expect again to see respiration rates far above that. The respirations simply are far too high clinically to support this overdose. We also heard testimony that if a morphine overdose would be an explanation for Grace's death, we would have seen clear signs of a drastically suppressed respiration rate within about 5 minutes. Dr. Goldberger talked about that. Instead, we see about 20 minutes after the actually saw a little bit of a clinical improvement that we didn't see for more than an hour after the morphine was administered. Respiration normal. If we were going to see a overdose, if we were going to pinpoint an overdose related to morphine, we would have seen that within 5 minutes. There were providers at the bedside. Dr. Schulter and Howard were at the bedside throughout that time. We just don't see that. It's not consistent. Clinical respiration rates and the pulse are just not consistent with what we would expect to see if we actually had. There's also been some talk about resuscitation. Scott Schara did not want it, did not authorize intubation. So I talked about that. Intubation was discussed with him on numerous occasions, probably about half a dozen times. Now, Grace did not need a ventilator. She needed a ventilator. Plaintiff contends that he requested Grace to be resuscitated at the time of the code, but the only resuscitation that we heard Dr. Verdine testify was to the administration of some sort of reversal. We know from Dr. Juror that really only mechanical ventilation been effective potentially. We also know that resuscitation would have been futile in the absence of mechanical ventilation. Dr. Verdine does not even suggest that CPR could somehow have been successful. That would be contrary to overdose. Keeping with that overdose theory, Dr. Verdine just talked about some sort of reversal. CPR could not have been successful at the time of Grace for a number of reasons. primarily due to the absence of sedation, mechanical vent. We call CPR stands for cardiopulmonary resuscitation, aspect of the heart. As Dr. Shokar noted, restart the heart, but it's just going to stop again. Pulmonary aspect, that's the part that's held in. Doctors and nurses had no way to address that pulmonary aspect. Even so, the plaintiffs are not contending that the CPR should have been initiated. The theory here is strictly one of a medication overdose. They contend that they ask the nurses to somehow reverse the medication that Dr. Shokar had more. But a reversal agent would have done nothing at all to fix Grace's lungs, to deal with the actual numbers that we're seeing here. They would have done nothing to change the picture of the x-rays that Dr. Binstock testified about. A medication reversal agent would not have done anything to fix profound oxygen deficit or extremely heavy breathing. Grace's lungs were damaged. A medication reversal agent would have done nothing that day because Grace's clinical condition was not suitable. Grace's clinical condition that day was driven exclusively by severe and progressive coronary disease. Packed her lungs and severely constricted her breathing. Not disputed that a nurse does not have the authority to remove a DNR from a patient's chart without a doctor or anything could be done, and that was only done after a discussion with the family. That was even testified to by Nurse Hiking. It's not something that a person can. Grace's code, as we've seen, happened fast. Recall again, Jessica's testimony. She thought within minutes. Certainly will suggest that that is the case. This is why these conversations occur in advance, pre-authorization conversations, because we need to know what needs to be done. There's McGinnis recognized that in one of her notes. I think it's clarification. Recall also Dr. Fisk talked a little bit about resuscitation. He mentioned that resuscitation again is not possible in the absence of mechanical ventilation. He even noticed that even with the administration of a reversal drug in this case, that would have done nothing for Grace's lungs. But in addition, he noted that even when a reversal drug is given, typically that's accompanied by the placement of mechanical ventilation of some sort. But again, that was not in the toolbox. It's really undisputed that Grace's doctors did not have mechanical ventilation in that. The medical evidence, in fact, is compelling based upon the Grace died reversal agents were not effective. I want to talk just briefly at the end now. I'll talk a little bit about it. You've been given a document called a special verdict. Talk about it. You asked to answer a couple of questions. From the perspective of the hospital and its nurse, really the only question. That question asks specifically, were one or more of the nurses at the hospital negligent with regard to the care by Schara? Based upon all the evidence we've seen over the past 2 weeks or so, I would respect this that question. So, when you answer no to that question, you won't be required to answer with respect to the hospital. There's also a question on the verdict. We call it a clause question. Simply asks whether the hospital caused injury or death to Schara. That's question number 6. I need to answer that question. You answer no to question number 5, although I believe it's abundantly clear that there's nothing that the nurses did with regard to Grace's hospitalization cause or resulting respiratory collapse. After all, when you look at the opinion, plaintiff's experts offer very little in the way of criticism that relative to the actual care that was practiced. Be far more interesting than the argument of Grace herself. The care of Grace, however. Answer question number 5. Now, there's been some suggestion in some arguments that, for example, The nurse is caring for Grace on October 8th should have informed Grace or her decision maker about some sort of medical event that was alleged to occur on October 7th or October 8th. The plaintiff claims, obviously, that Dr. Devine, that Grace experienced an overdose of Prestex on first when Sam Hayes was commenced with titration on October 7th, and later when some medication was actually for Grace blood pressure on the 8th. Well, Nurse McGinnis, Nurse Keats, Dr. Garibald, several of the witnesses made it quite clear to us that there was nothing that occurred on the 7th. Now, on the 7th, it was a Sam Hayes starting to do the titration of the necessary anti-anxiety medication. Doctor started it as he should, starting the titration date that the doctor ordered, and then he immediately depression style got the level of anxiety and anxiolytic properties. Both instances complete medication were occurred in close observation in ICU setting for known potential side effects. Grace never experienced it. The word that we use when those ICU with nurses have explained exactly what was going on there on the set. There was nothing unusual about that happened all the time. Sam says now the right dose for Grace on that date. Achieve the level of sedation. In addition, I've not been instructed. You're not going to be asked to answer any issue for informed consent. Nurses don't have an informed consent. Not been instructed that even if some medical event could have related to medication could have to occur sometime wouldn't be nurses on both those things. That would be generally an informed consent. We do advise position. Nurses report to doctors. Doctors have conversations with patients. But the doctors caring for Grace on the 7th and 8th are not defended. There's no allegation that they did wrong. They're the ones who have the conversation. There wasn't, of course, but it's not an accurate statement for that responsibility. And then the doctor decides what family. No nurse had a duty to that occurred and would have required such a conversation, nor is there any required conversation. Also, Grace on October 10th. October 10th was the day when Schara was asked to leave the hospital. Even if this argument had anything at all to do with Grace's death, COVID, those articles Indian calm conversation. Hospital that day. She in fact took steps to set up a virtual visitation concept with him before he left. That was set up today. She was able to set up to make sure that her schedule keep the Schara's updated up on what happened. This is in fact how all patients were care with all POAs and family members were in that. Communication was done pretty typically. But of course, there was a recognition here that Grace's sister was indeed allowed to come in that day. This is that which she recognized. that were particularly we also heard that Nurse Catherine Hale, she was the RN who took over on she had multiple conversations with Scott Schara was also given the number of it and the number for Nurse Barcodes herself. And if you really look at those nursing communication on other quite and unrelated in any way. It was also suggested and argued that the nurses did not create some sort of plan to get a replacement for Scott, or someone coming on to replace Scott. Again, this is has nothing to do with the advancement of racist health disease. It has nothing to do all with the cause of death. First, as Attorney Mendenhall asked, see Mr. Schara's absence from race really had nothing to do with her death. She passed away on the 13th. Her sister was there on that day as well. There's also no evidence that any nurse had a data to get a replacement for Scott on the end. You see that Allison Markle did in fact sit down and create a plan for virtual visitation for that day that was implemented, and virtual visitation was in fact what occurred on that day. Scott's testimony, or Scott Schara's testimony, is that he dealt with the hospital administration the next day and make sure that the hospital and that Jessica understood the parameters, for example, wearing PPE, things like that, to avoid her getting sick. And that was approved the very next day. The nurses were caring for Grace. They weren't caring for her father. They had communication. Certainly they did. Allison Markle certainly did. But the nurse's responsibility was caring for patients. We heard from Nurse Davis. They were not necessarily, or they were not involved in negotiations to find a replacement. Their role was a care role, and certainly a replacement for Scott was in fact found and completed the next day. There was no particular responsibility. There was no standard here that all the nurses having to, take away from their race and negotiate a replacement for Scott. In fact, Jessica did come to the hospital the very next day. The nurses weren't involved. The nurses weren't supposed to be involved. The nurses, again, and that's exactly what they did. It's also been argued that the nursing staff somehow failed to communicate with Grace or her POA. That was the day, obviously, when Grace passed away. That would be Nurse Holly McGinnis. She was there that day. She was fine. Now, Holly had no duty to communicate with Scott Schara. She was the nurse at the bedside. The records show Dr. Schokar was communicating with Scott Schara that day. Now, Holly McGinnis was communicating with Jessica. She was at the bedside. Jessica had questions. She was with Jessica. Jessica admits Holly answered her questions. Jessica was in contact with her family at all times. Holly had no even a reason to discuss anything else specifically with Jessica. Jessica wasn't a designated decision maker. Her parents were, which is why Dr. Schokar had conversations. She had no reason, Holly didn't, to have any type of discussion with Jessica at the bedside at that time, because she had a DNR order in the record. She had no reason to question that. She was not involved in discussions. It never came up. And certainly her role would not have been to discuss that with not have an important consent relative to addressing the DNR issue. So there simply wasn't on the part of Holly to give us to have such a discussion with Jessica, who was also the sister, the representative actually here with her sister at that time. It's also been argued in this case that the nurse's presence on the unit at the time of Grace's arrest were at least suggested or somehow required to ignore a valid DNR order in charge in violation of the undisputed, however, that a physician would need worker, would have very fast vital signs. Nurses are prohibited from acting unless the physician would have a discussion about the DNR with the family, or the issue. And it would not be consistent with the standard of care for the nurses to act in the absence of actually dealing with it. Dr. Shokar had already left. He was gone from the hospital at that time. So that wasn't the issue. But the nurses cannot just jump. Well, no, it is not. It is undisputed, in fact, that the nurses did not have the ability or the authority to revoke or to ignore the DNR. There simply wasn't enough time. Reach the end of the evidence. The evidence in this case shows that the hospital's nursing staff applied to this case. There are several defendants on the case. One entity, the one that's actually responsible for Gary Schara's death, however, is not on the case. Can't put COVID-19 on the verdict. Medical evidence based upon everything that COVID was involved. None of the defendants breached any standard on that breach. Grace's death was a tragedy, and unfortunately, it occurred all too often during the illness. Every one of those patients, everyone that Dr. Knight testified were all sad versus saw. 19 months out of this period. Nurse Aiken had 3 months. Nurses saw that week after week, over and over again. All of the physicians and the nurses treated Grace actively to at least give her a fighting chance within the bounds of the which I would ask that you acknowledge this fact when you answer no to question 5 on the verdict.
Thank you, Attorney Krakowiak.
Set up.
Take your time. So just to maybe cover things.
for your service. So closing argument is my opportunity to present to you my view of the evidence that was admitted during the course of the trial and how to apply it, and also walk you through how I think the law applies in this case. When we started this process 2.5 weeks ago, when I stood up in front of you in my opening statement, I mentioned that you were here to resolve a conflict. The conflict between Mr. Schara and Dr. Shokar as to whether Dr. Shokar met the standard of care when he was providing care and treatment to Grace Schara, and whether he met the standard of care for informed consent. That remains the conflict that you are here to resolve. 2.5 weeks ago, we were in the other courtroom going through the process of jury selection. The fancy term for that is voir dire. Voir dire, ask 5 attorneys, they'll all pronounce it differently. But when translated, it means speak the truth. One of the last things you hear before you go back to deliberate is an instruction that contains the phrase, let your verdict speak the truth, whatever the truth may be. And that's what this whole process has been about for the last 2.5 weeks. It's a search for the truth. It's looking at the evidence, applying the law, and determining what the truth is in this case. How do you go about doing it? Well, I think it's very similar to putting together a jigsaw puzzle. Attorney Frank Koyak alluded to puzzle pieces. When brand new jigsaw puzzle, you open up and you dump out the box and all the pieces are on the table. We're the ones that dumped out the box with all the exhibits. I think most people then, when they put their puzzle together, they use the cover as a guide. In this case, the law, as instructed to you by Judge McGinnis, that's your guide. Your verdict, and you've heard it in the instructions already, your verdict must be based on the evidence and not sympathy. And I know that is a hard thing, and we'll talk about that. It is rather remarkable to me, as I sat and listened to plaintiff's closing argument, that it would be said, well, the defense is going to talk about COVID. Yeah, we're here to talk about COVID. Everything you need to know about this case can determine by looking at these images. Because these images show you the true story of what was going on with Grace while she was hospitalized at St. Elizabeth. I know a lot of the timeline has been covered. I'm going to try to hone in on what I think are some of the important highlights. Upon admission, Grace, an X-ray was done and a CT scan was done. You might recall that Dr. Binstock prepared an exhibit that showed you Grace's CT scan upon admission. And you probably remember that when Dr. Binstock was here, he had his laptop and he had the special software that he could show you what was actually going on within that CT scan. Call from this exhibit that up here is what a normal CT scan looks like. This is a CT of early COVID. And I do have this up on the board in a later slide, so we'll go over it again. This was Grace Schara's CT scan at admission. Yeah, there's a little improv going on here. Okay, thank you for letting me know. This is clearly a situation where Grace enters the hospital with moderate to severe COVID. She's been a sick girl for a very long time. Very sick girl. On October 7th, in the evening, Precedex has started due to Grace's agitation. And we all know that Precedex is one of the big issues in this case. I'll talk quite a bit more about it in a minute. Additional x-rays were done on the morning and the evening of the 8th, which show continued progression. On October 9th, Dr. Murata is one of the first of several doctors to bring up the topic of intubation with Mr. Schara. On the 11th, yet another x-ray shows further deterioration of Grace's lung condition. And that kind of sets the stage for when Dr. Shokar begins providing care and treatment for Grace Schara. He takes over on the morning of October 12th, and in the process of taking over Grace's care, he has what's known as a handoff or report with Dr. Carl Baum. And in that conversation, Dr. Shokar learns about Grace's condition, what's been going on with Grace, what the BiPAP say, what our oxygen requirements are. He also learns that there hasn't been a formal entry into the medical records about intubation status. So one of the first things that Dr. Shokar recognizes as he takes over Grace's care is that that situation has to be resolved, because the staff needs direction as to what would happen if Grace went into cardiac arrest. Dr. Shokar also reviewed Grace's medical chart, all the records of her previous care. And after doing so, he explained how he did this. He arrived at a differential diagnosis. And in this case, it was more of a confirmation. After looking at all the information, it was a confirmation of the existing differential diagnosis. Grace in the morning, and he noted that Grace had had a good night. She seemed to have stabilized. Unfortunately, Grace's condition deteriorated over the course of the rest of October 12th. That prompted Dr. Shokar to prepare a note on the afternoon of October 12th, and also have a discussion with the Schara family. Discussion, he relayed to them that Grace's current clinical presentation required BiPAP at max settings, max pressure, 100% oxygen. Counsel, in opening statement, referencing this same time frame, said, well, her oxygenation rates were in the 80s, the 90s. Dr. Garibaldi told you. Dr. Garibaldi told you that we're all in the 90s right now on room air. In order to achieve that level, when we're talking about room air, we're talking about 20% oxygen. So in order to achieve that same level with Grace, they had to have her on a machine that was giving her 100% oxygen. 100%. Grace did not have a good day. She may have had a good morning, but it wasn't a good day. Continued to deteriorate throughout the day. Schara family. If you remember, he initially contacted Cindy Schara and started the conversation. And at some point, the conversation got emotional, and understandably so. And Cindy Schara told him, you need to talk to Scott. So in the course of that discussion, they discussed worst case scenarios. If Grace stays on BiPAP, what happens? Well, at some point, since she's already on max settings, there's going to come a point in time where that machine isn't going to be able to support her oxygen levels. And Dr. Shokar explained to them at that point, Grace will pass. We talked about intubation as well and those types of scenarios. And I believe Dr. Shokar made it very clear that even at this point in time, given Grace's condition, was not a guarantee, and intubation actually had a very small chance at preserving Grace's life. But he explained what that would look like if she was intubated and if she made it out of the hospital. The likelihood was that there would be long-term damage to Grace's lungs. We saw a note from Dr. Gandev during Dr. Garibaldi's testimony in which he described fibrosis in the lungs, or the beginning of fibrosis, scarring, long-term damage, not going to be fixed. And so even if Grace made it out of the hospital, the likelihood was that at a minimum, she was going to need a long-term rehabilitation and quite possibly the use of supplemental oxygen for the rest of her life. That was all explained to the Schara family. Dr. Shokar told the Scharas that he needed a direct answer on intubation. And then he also started the discussion about intubation in the context of cardiac arrest due to respiratory failure. And as Attorney Frankowiak mentioned, if you can't, and this was testified to by Dr. Garibaldi, was testified to by Dr. Shokar, if you cannot address the underlying cause of the cardiac arrest, in this case respiratory failure, and that means address it with intubation, CPR, defibrillation, all that is futile. Because all you're doing at that point is you're doing compressions on a heart that is pumping unoxygenated blood. Blood has to be oxygenated to feed the tissues, to feed the organs, to keep you alive. And if all you're doing is moving around unoxygenated blood, it doesn't matter. Eventually the heart will die and you're not going to be able to bring it back. In other words, without intubation, resuscitative measures were futile, and Dr. Shokar explained that to them. He documented in his note that all questions were answered and that the conversation took 60 minutes. That brings us to the morning of October 13th, 2021. Again, Grace's clinical condition is getting worse. BiPAP settings again at max pressure, 100% oxygen. But equally important is the fact that they tried to wean Grace down to 90%. They tried that. Her stats dropped down to 80%. She could not maintain her oxygen saturation levels without that BiPAP machine on max settings. Dr. Shokar also documents agitation, pulling at the mask, pulling at the PICC line. And he documents the need for ongoing use of Precedex. Something else in that note, the lab results. I don't know if you remember talking about the lab results with Dr. Garibaldi and Dr. Shokar. But at that point in time, the lab results showed that she'd spiked a fever. Her dimer had gone up from, I believe it was 2,300 to 23,000 on Friday. Indications of what Dr. Shokar referred to as a cytokine storm, or an inflammatory response to the ongoing COVID infection and the ravaging of Grace's lungs. An inflammatory response which, as Dr. Shokar described it, the body starts to do damage to itself. That's what was going on the morning of the 13th. Dr. Shokar has a conversation with the Schara family to follow up on the previous conversation and also to update them on condition. They discussed nutrition, and the family consented to the insertion of an NG tube. Family informed Dr. Shokar at that point that they had elected for do not intubate status, DNI. At that point, Dr. Shokar then had an additional conversation about CPR and the futility of resuscitative measures in the absence of the ability to intubate. Dr. Shokar documented that conversation in his note. He also documented that there still was the goal of improvement. Nobody was giving up on Grace Schara at that point. Absolutely not. Everybody in that hospital that was taking care of Grace Schara was doing what they could within the parameters of the family's wishes to save Grace's life. And so when Dr. Shokar references getting her up in the chair and getting her moving around and watching TV, as he told you, that was a long-term goal. He never told the Schara family that that was going to happen on that day. How could he? She's on a BiPAP machine, basically providing all of her breathing support. She's in a bed. Told them that that was the goal for the day, and he never told them that Grace had a good day, because that wouldn't be true. Throughout the course of the day on the 13th, Dr. Shokar, on his own, and also through the eyes and ears of Holly McGinnis, continued to monitor Grace's condition. And Attorney Frank Koyak went over all the vital signs to kind of bring you up to speed on that. But Dr. Shokar was working with Holly McGinnis to try and figure out the best way to deal with Grace's ongoing deterioration, the high respiratory rate, the low oxygenation levels, and they had limited options. So that respiratory rate is increasing, 40s into the 50s, 55. Nobody can sustain that type of respiratory rate for very long. I don't know how Grace managed to do it for as long as she did, but she did. Obviously, Grace was a fighter. Clearly was a fighter. She was a lot of things. She was a very vibrant young woman with an amazing sense of humor, but she was a fighter. This has now reached the point where in an emergency situation, Holly McGinnis gives lorazepam at 1746.5 milligrams, consistent with a PRN order by Dr. David Beck. She realizes that that medication, that 0.5 milligrams, had absolutely no effect on Grace in terms of trying to get her respiratory rate under control. Dr. Shokar brings him up to speed on what's going on, and Dr. Shokar gives a verbal order for a third dose, or a dose of 0.5 milligrams of lorazepam to reduce the work of breathing and buy Grace some more time. Unfortunately, that had no effect, change in condition. And how do we know that? Well, Dr. Shokar, after giving the verbal order, comes down bedside by Grace, and he's monitoring her. He's monitoring her to make sure, number one, that there is no side effect reaction after administration of lorazepam. And he also wants to see if that order has any, or that medication has any effect. And unfortunately, he doesn't. Ultimately, he's working. Dr. Shokar is in the position, as Dr. Garibaldi put it, the impossible position of having very little in the way of options to address Grace's issue. The respiratory rate, the low oxygenation levels. at 18:15, recognizing that Grace is now 50. 55, Dr. Shokar testified that he saw at least one reading at 60 breaths per minute. Dr. Shokar is faced with an emergency situation and he has two options. Since intubation is not an option, two options. Do nothing and watch Grace go into cardiac arrest and pass away, or do something to try to buy her, get her through this inflammatory response. Dr. Shokar makes the decision to order 2 milligrams, small dose of morphine, 2-3 tablets of Tylenol 3 are the equivalent, to see if that will have any effect. And you know, I saw the clip of Dr. Burdine talking about this being, I don't know if he said it was the most egregious. When you parse out what Dr. Burdine said, and I took notes here, giving morphine to an unconscious patient with no blood pressure, no pulse. That's what he said. Conscious. At best it was somnolent, and there is a clinical difference. Somnolent means very sleepy, but arousable, unconscious means what we all know it means, unresponsive. There's a clinical difference, and Dr. Burdine knows that. He knew that. And that the record doesn't reflect unconscious, it reflects somnolent. No blood pressure. False. How do we know that? We know that through Dr. Shokar's testimony, that when this incident came up where the monitors weren't picking up a blood pressure, he did things the old-fashioned way before we had electronic monitors and everything like that. He went through, checked the pulses in all the appropriate locations to verify that there was a blood pressure and to verify that there was a pulse. So when Dr. Burdine says no pulse, Dr. Burdine, that's false, not true. So Dr. Shokar administers or orders the 2 milligrams of morphine. He remains bedside to monitor because he knows that if there's going to be any type of adverse reaction, it's going to occur within minutes. But obviously, he also wants to see whether this intervention has any effect on Grace. Her condition improved and stabilized, at least for the time being. Her respiratory rate drops into the 40s, still well beyond what's normal, and still a respiratory rate that in the long run would be hard to maintain. And her oxygen saturation level increases to 95%. As I said, there's only so much a body can take. And when you're breathing that at that level, 40, 45, 50 breaths per minute, you're malnourished. You're fighting an inflammatory response. At some point, the body says, I can't do it anymore. I just can't do it anymore. Grace suffered cardiac arrest around 7:25 p.m. and was pronounced dead at 7:27.
Why some of the things that we're seeing here are not consistent with an overdose. But it also tells us how Grace was doing in the
of attorney Alan Jackson. I don't know, maybe some of you are familiar with the Karen Reed case, but he gave a phenomenal closing argument. And in the course of that closing argument, he made the following comment that I thought was appropriate to this case. He said, science is the silent witness. In this case, it's medicine is the silent witness. Well, at least of the case. The plaintiff and Dr. Burdine completely ran away from the medicine in this case. There's a reason you didn't see this in their case. There's a reason you didn't see all the x-rays in the case. There's a reason that they hide from you the BiPAP settings and how desperate Grace's need for oxygen became. Because if they told you any of that, if they mentioned any of that in their case in chief, the jig is up. It's COVID-19, not a drug overdose, not a medication overdose. They couldn't show you that because it doesn't fit with their cherry-picked theories, data from certain parts of the record. It doesn't fit. It's not the real, theirs is not the real medicine. This, you had to wait until the defense started presenting their case to see key pieces of medical information. They kept that from you. Add admission with this. Explain to you that the problem with the admission x-ray or any x-ray is sometimes it's only the tip of the iceberg. He demonstrated that through his radiology software and going through the CT scan. You've seen this multiple times, and like I said, that tells the story of this case visually. So, Attorney Administrator in his opening statement talked about credibility of witnesses. And I think it's fair that we talk a little bit about Mr. Schara's credibility. Ultimately, it's your assessment to make. Odd. Of this case is that nobody ever told the Schara family that Grace was on Precedex, right? That's been one of the themes. But let's think about that for a little bit in light of the things we know about Mr. Schara. We know he was a researcher. He was recommended to give Grace tocilizumab. Mr. Schara did research on his laptop, then consulted with a family friend, and based on that, he made the decision to decline tocilizumab. When the topic of ventilators came up, Mr. Schara got on his computer, researched ventilators, came to the conclusion that he came to and decided that Grace was not going to be put on a ventilator. We also know that Mr. Schara wasn't afraid to ask questions. He wasn't afraid to challenge nurses and doctors. We know he was in Grace's room from October 7th to October 10th. And we know that he, at times, was silencing alarms, turning off alarms, however you want to characterize it. When you take that all into consideration, how plausible is it really that when Mr. Schara is in the room on October 7th, when they start the Precedex, that not a single person, doctor or nurse, told him what they were doing? How plausible is that? Maybe even a better question is, how plausible is it, given what we know about Mr. Schara, that he wasn't watching what was going on and asking questions? Really, is it plausible that he didn't ask a single question? Didn't make any inquiries as to what was going on? Supposed over-sedation events occurred, which are really known side effects of a medication used routinely in an ICU. Is it plausible to think that he's in that room and there's activity and there's bags of medicine being hung from IV poles, that he didn't ask a single question? That he didn't read any of the names of the medications on the bags? That not a single physician or nurse said a word to him about that? It's not plausible. In fact, we know that Jessica Vanderheiden, immediately upon walking in that room, saw the Precedex machine and asked questions. If Jessica saw it and asked questions right away, is it plausible to believe that Mr. Schara didn't see the machine or didn't ask questions or perhaps maybe even do some research? about in terms of the DNR, DNI? First, it's important to note that Dr. Shokar's progress notes documenting these conversations are the contemporaneous record of the conversations. They're not just his testimony almost 4 years later. What you heard from Mr. Schara is the testimony that he's given in a lawsuit 3.5 years after the event. He comes here for the first time, he gets on that stand, and for the first time we hear, well, if they just told me that she needed to be intubated to survive, I would have done it. First time comes into this courtroom asking you to award damages. Mr. Schara's position on intubation and ventilators was consistent up until the time he started this lawsuit. In terms of the conversation on the 12th, Dr. Shokar didn't deny that the conversation was 60 minutes. He confirmed that. He confirmed that Dr. Shokar spoke extensively about ventilation. He admitted that a discussion took place regarding what would happen if Grace's heart stopped. Dr. Shokar asked, would you want us to keep working on it? The response was, do your best, and God will do the rest. But we find out on Tuesday, through Mr. Schara's testimony, confirming his previous deposition testimony, that came with a caveat. Do your best, and God will do the rest, with the caveat that we do not want her to be intubated or ventilated. Now I want to be very clear on something. Medical decisions are personal. And people have their reasons for making decisions. And it's not my place to be critical of that decision. As Dr. Shokar said, in these types of situations, there is no right or wrong answer. That being said, decisions have consequences. And in this case, decisions had consequences for Grace and also for the healthcare providers that were taking care of Grace. Credibility of expert witnesses. Attorney addressed that. The bottom line is this: in order to find Dr. Shokar negligent in any respect in this case, you have to find that Dr. Berdine is more credible than Dr. Shokar. Dr. Goldberger, the toxicology expert, Dr. Fisk, infectious disease, Dr. Binstock, board-certified radiologist, Dr. Garibaldi, board-certified in pulmonary medicine and critical care, and Dr. Beach, an ethics expert. As you might expect, I have a few things to say about Dr. Berdine. First of all, one of the instructions that you received, a couple of them, talk about the actual standard of care. What is the measure? And remind you that it reads like this. Dr. Shokar was required to use the degree of care, skill, and judgment which reasonable hospitalists in the intensive care unit would exercise in the same or similar circumstances, having due regard for the state of medicine or medical science at the time Grace Schara was treated. Emphasis on reasonable hospitalists in the intensive care, same or similar circumstances. Dr. Shokar was a hospitalist. Dr. Berdine was not. Dr. Berdine was a pulmonary consultant in what's known as a step-down unit. Step-down unit was, his step-down unit was taking care of patients who had been discharged from the ICU and were in the process of recovering. Dr. Shokar was taking care of the sickest of the sickest of the sick. same or similar circumstances, not the same specialty. Heard about metabolic acidosis. And I know Attorney Frank Koyak mentioned this, but I thought it was important to bring it back in the context of what you heard it at trial. I asked Dr. Berdine a series of questions about reviewing the medical records before he wrote his first report, before he wrote his second report. You may remember that. I asked him at that time, Dr. Berdine, can you show me anywhere in these two reports where the words metabolic acidosis show up? And remember his response as well, these are kind of long reports. And so I asked the court for a break so he could review the reports. He did finally admit that they weren't there. Dr. Berdine wrote those reports. He knew that all along. He knew those words weren't in there. It took him 3 reports, 2 years of reviewing medical records, and a deposition taken by me in which I'm asking him questions about his theory of overdose in context of the vital signs. That's when the light bulb all of a sudden went on for Dr. Berdine about metabolic acidosis. 2 years of those medical records, and he comes up with it at the last minute. How credible is that? Precedex. We know he never ordered, never set titration parameters. We know his opinion on Precedex is based solely on the package insert. A package insert which Dr. Garibaldi told you no critical care doctor who uses that medication every day considers that to be standard of care. It's not even used as a guideline. It's clinical practice. It's how it's used in clinical practice that sets the standard of care. And Dr. Garibaldi was clear that the manner in which Precedex was used in this case is the standard of care. The guy who's never used the medication in clinical practice, or the guy that uses it every single day. Experience with the drug itself, possible side effects. One. If Grace had gone home, she would have survived. How on earth can that be an accurate statement, given the condition of her lungs? It's absurd. Garibaldi's testimony about what it takes to maintain someone on BiPAP at 100% oxygen. He said, there's no way you can do it in a home setting. Even if you daisy-chained oxygen concentrators together, you could not come anywhere near the level of oxygen that Grace needed to survive. And that doesn't even touch on the point that there'd be no critical care there. If that wasn't enough for you to question Dr. Berdine's credibility, mind you of the statement made in plaintiff's closing about just because you raise your hand, swear to tell the truth, doesn't mean you tell the truth. Remember that? Remember this one. For the proposition that, look, this 50 or 55-year-old or 54-year-old patient, his lungs were worse than Grace's look like. But remember what Dr. Berdine didn't tell you and came out on cross-examination? That man was intubated. He was on a ventilator, and the ventilator helped him survive. Dr. Berdine could have been fair and objective with you and honest with you and tell you, well, in all fairness, this man was intubated and survived. Counsel could have made that clear, but they didn't. Dr. Berdine didn't. Aside from the fact that that x-ray proves a good portion of this case, that ventilators save lives when people have COVID, this was a deliberate attempt to mislead you. And when an expert witness engages in a deliberate attempt to mislead you, that ought to have you question everything he says after that. Everything. What is he not telling me? What else did he hide from me? You know, if you are an expert witness like Dr. Burdine, and you're going to come in and accuse that man of committing malpractice, it seems to me that you owe him the duty to be fair and objective and not be an advocate. More importantly, Dr. Burdine owed it to this process, and most importantly, he owed it to you. He violated that duty. So let's talk about the defense experts. You've seen Dr. Binstock's qualifications. You know all about him. You've seen his work through these x-rays. Oops, went too far. Dr. Binstock's opinions. She was admitted with moderate to advanced COVID-19. The imaging establishes that her lungs continued to deteriorate through the 13th. The images are consistent with COVID-19 and ARDS, and that by the time she got to the 13th, her lung capacity was 20%. Dr. Garibaldi, again, to try and dispatch of this whole absurdity of metabolic acidosis. Remember, Dr. Burdine cherry-picked data, in particular one, bicarb of 19, and they talked to you about base excess and all that. Dr. Garibaldi came in and told you, number one, nobody uses base excess to determine metabolic acidosis. It's determined by pH. He also told you that he looked at the ABGs up until the 12th, and he, I think to his credit, admitted that he did make a mistake in his report. That he looked at the medical record wrong and failed to distinguish between the 12th and the 13th. But he was honest about that with you, that I made a mistake. Because the ABGs up to the 12th tell the story. And instead of a metabolic acidosis, Grace was experiencing a opposite. Dr. Garibaldi and Dr. Schokar talked about the concept that there could be a secondary metabolic acidosis, but it's not the metabolic acidosis that Dr. Burdine was trying to sell to you. The kind of metabolic acidosis that Dr. Garibaldi referenced is a response to her alkalotic state, and is completely appropriate. Dr. Garibaldi, you know about his qualifications, where he went to school and all that, but I think what he brings to this case that nobody else does, and certainly not Gilbert Burdine, is his vast knowledge about COVID-19. You might remember that Johns Hopkins during the COVID pandemic was front and center. They had the data that showed the ongoing cases, and it was like a heat map. You could see where there were outbreaks and where there were surges. He was involved in that. He has dedicated a substantial portion of his time since COVID, since COVID started, researching, writing, and giving presentations on everything related to COVID. Dr. Garibaldi testified that the care and treatment provided by Grace's healthcare team met the standard of care. That when she entered the hospital on October 6th in the ICU on the 7th, she had severe COVID-19 and her lung condition continued to deteriorate over the course of her hospitalization. Confirmed that Dr. Schokar did not need to obtain informed consent to use lorazepam or morphine. Number one, because their medications routinely used in the ICU. And number two, Dr. Schokar was confronted with an emergency in which his only two options were lorazepam or morphine, or do nothing. Ordering lorazepam and morphine on October 13th to reduce Grace's respiratory rate was reasonable and did not violate the standard of care. That's what Dr. Garibaldi testified to. Dr. Garibaldi also issue of the do not resuscitate order. He told you that he's had these discussions. He's seen notes from other discussions, and the notes prepared by Dr. Schara were some of the most detailed notes on these types of conversations he's ever seen. Dr. Garibaldi was clear in that intubation was the best option to preserve Grace's life, and that without it, resuscitative measures would be futile. He also told you that Grace Schara's death was caused by acute hypoxemia due to COVID-19 and not a medication overdose. Dr. Beach. Dr. Beach has dedicated the last 20 plus years of her career researching all kinds of issues involving medical ethics, DNRs, informed consent. She told you that at the time that Mr. Schara consented to have Grace admitted at the hospital, that was implied consent. Implied consent includes use of routine medications, in this case, lorazepam, Precedex, morphine. And that the use of those medications did not require a separate informed consent discussion. She also told you that since Dr. Schara did not order the Precedex, he had no duty to have any type of informed consent conversation with Scott Schara. She confirmed that the orders for lorazepam and morphine, since they were given in an emergency situation, did not require informed consent. She confirmed what Dr. Garibaldi said about the appropriateness of the conversation on the DNR, that it was within standard of care, was properly documented, and that it's clear that the family gave consent to enter that DNR. She confirmed that standard of care when it comes to a DNR does not require a witness, does not require a document signed, in this case by Mr. Schara as the patient representative, require the use of a bracelet. So we're at the portion of the case where it's now time to look at the law, discuss the law a little bit. 15 minutes.
Rush anybody. This is too important to try to cut somebody off by 10 minutes or 15 minutes. So I want them to have their final say to however long it takes. Same thing on how the whole trial works. But the food is there for you. It's 1 o'clock. You know, you haven't eaten since 8 o'clock, so I want to be respectful. I know the attorneys are going to want to get something to eat. So what I'm going to do is the minimum. I know you guys would probably like to eat and get back in here. But the minimum I'm going to do is 30 minutes. And when you go back to the jury room, if you'd like more, so that you can do the things, the phones will be given to you as well. Just let the bailiffs know right away that you'd like more than 30 minutes. Tell us how much you'd like, and then that's the amount of time we'll take. The jurors are excused. You may be seated. This is a hearing outside the presence of the jury. You know, about 10 minutes ago, I was going to give them a break for lunch after you were done, because you had said 40 minutes. And it's been 51, but I figured it was plus or minus 30. You know? So how much time do you? Yeah, 30 minutes plus or minus 20. That's good. I'm bigger than that. I told Dr. Shokar I need to lose. Okay, do you guys want more than a half hour? Okay, I only see Mr. Boylan saying yes, so you're good, Mr. Administrator, if we give the jury 30 minutes? You're the one who has to do something to Mr. Guzzi. Does that work?
I could do it, sure.
Okay, so let's do 30 minutes. If we hear something, we'll let you know right away and it'll be longer. I'll do that email to the group.
Okay,
Otherwise, let's plan on 1:30.
all right.
All right,
Thanks.
we're adjourned.
You by the greater weight of the credible evidence to a reasonable certainty. Keyword is credible. Can't be just any old feather. It has to be a credible feather. You by the greater weight of the credible evidence to a reasonable certainty. Keyword is credible. Can't be just any old feather. It has to be a credible feather. Reasonable certainty means that you are persuaded based upon a rational consideration of the evidence. Absolute certainty is not required, but a guess is not enough to meet the burden of proof. If you have to guess at any answer, plaintiff has not met their burden of proof. Burden of proof. So let's take the evidence and now apply the burden of proof to the evidence. On October 12th and 13th, Grace Schara was in the final stages of COVID-19. Her lungs, 20% lung capacity. She was dying and her condition was emergent. Respiratory rates in the 60s, low oxygen sats. For Dr. Shokar, he was in the impossible situation based on honoring the Schara family's wishes for a DNI. But for him, doing nothing was not an option. Did not breach the standard of care with regard to the care and treatment he provided to Grace Schara. Whether it's the order for lorazepam or the order for morphine or his monitoring of the Precedex on the 12th and 13th. As you saw, Dr. Shokar was in contact with Holly McGinnis. Holly McGinnis was charting the RAS score, the vitals, and Dr. Shokar was making notes in his record about what he was seeing as far as the level of Precedex and why it was needed. And when it came time at the end, before he ordered that morphine, he ordered that the Precedex be shut off. Not because there was anything that he felt was, that Precedex was causing. It's because he wanted to take it out of the equation before he administered the morphine. The overwhelming evidence in this case is that the cause of Grace Schara's death was acute respiratory failure with hypoxia due to COVID-19 and not an overdose. That's the overwhelming evidence. That's the credible evidence in this case. As far as informed consent, Dr. Shokar had no duty to obtain conformed. I'll have to talk to my legal assistant about that, which is me. Informed consent regarding Precedex. Dr. Shokar's notes established that he was monitoring the continued administration of Precedex and the continuing need for Precedex to keep Grace calm, anxiety and agitation, to allow her to focus on breathing. I mentioned that Dr. Shokar ordered the Precedex be turned off. The orders for lorazepam at 1749 and the order for morphine were given in an emergency situation and no informed consent was required. And that's not only coming from our experts. Although Dr. Burdine was talking about different forms of medications, he acknowledged that medications can be given without consent in an emergency. He also acknowledged that it's the physician at bedside who is in the best position to determine whether a situation is an emergency. When you put those pieces of testimony together, there really is no dispute in the record that this was an emergency situation as determined by Dr. Shokar. And because it was an emergency situation, the administration of those medications did not require informed consent, and Dr. Shokar did not breach the standard of care. Burden of proof on the DNR, the evidence. Dr. Shokar's progress notes and his testimony established that the discussions he had with the Schara family on October 12th and 13th were within the standard of care. That's confirmed by Dr. Garibaldi, who has had similar conversations, and Dr. Beach, who is an expert in ethics. Further, Dr. Shokar testified that he has never entered a DNR order without the consent of the family. And in this case, he testified that he would not have entered a DNR order in this case if he was not absolutely sure that the Schara family consented. The feeling of sympathy could be overwhelming. I don't think there's a single person in this entire courtroom that doesn't feel sympathy for the Schara family at the loss of Grace. Not a single person. And if you feel that way, that's okay. But I'm asking you for courage. Courage to build a wall between that feeling of sympathy and your job, your duty to decide this case on the evidence. Courage that if the conversation in that
or these are worthless. Dr. Binstock admitted that his analysis was purely subjective, that the read of those types of x-rays are not at all objective evidence, that it's one person's interpretation of films. And it's almost impossible to get two people to agree on what they show. Having said that, I think it's probably imperative that we start back with Mr. Frankowiak. You know, he's talking about the theme of the case and being sympathy. Mr. Goosey mentioned that to you. They're trying to play on your emotions, that all we have is sympathy here. We don't have just sympathy. We're not running away from the medicine at all. In fact, we're the ones that put up all the medicine that is credible, that is reasonable in this case. And all they've talked about is COVID, COVID, COVID. They just want you to believe that this was a pandemic and therefore she was going to die. She was going to die of COVID. She had COVID. It was an irreversible course. You're intelligent enough to know that that is absolutely, positively what we call a red herring, right? Why else did Mr. Frankowiak spend almost 30 minutes beating up on Scott Schara, bringing up all these things about, you know, his research and, you know, trying to show that he's some sort of a kook, right? None of that has anything to do with Grace, not a single thing. Doesn't have anything to do with proving how Grace died. You just witnessed by Mr. Frankowiak a classic definition of red herring. That being that which misleads or distracts from a relevant or important question, leading toward a false conclusion. That's what a red herring is, and that's what you saw in that entire discussion that Mr. Frankowiak put before you. You know, I'm reminded of that phrase, you can't see the forest for the trees. And what we saw during that dissertation was a whole lot of pretty trees. That's all he talked about were trees. Why is that? Because he's got to focus in on trees so that you don't look at the forest. Keep that in mind when you begin your deliberations. I believe he was the one that said that Mr. Schara would not have allowed for a mechanical ventilation, quote, at any point. Now, these are my notes as Mr. Frankowiak was talking, and I put it in quotes, at any point. Mr. Goosey then stood up and he talked about the fact that we were running away from the medicine, that we weren't willing to talk about the medicine, and that Mr. Schara refused to consider intubation or mechanical ventilation. Well, let's try and, yeah, there we go. So this is Scott Schara's sworn testimony, and we're starting, would that have changed your thought process on whether or not you'd have Grace intubated? They're talking about a discussion between Mr. Schara and Dr. Shokar, right? That whole, you've heard about it countless times. And the question, would it have changed? And his answer, if he said to me, the only way to save her life is with intubation, would it have changed my mind? Yes, it would have changed my mind. So that's the testimony of Mr. Schara. And that question was posed to him by Mr. Goosey. He sat there face to face with Mr. Schara and asked him that question and got that answer under oath. So for him to come into this courtroom, along with his partner, Mr. Frankowiak, and try to claim that Mr. Schara made a reasoned decision with informed consent, being that he was not going to allow for intubation under any circumstances, is a blatant falsehood. And he knows it because he got that answer over a year ago under oath. Mr. Schara said he wasn't willing to give pre-authorization. And I think he used the example, that's like if I were to go into the hospital with a sprained ankle and they asked me to give a pre-authorization to amputate my leg. I thought that was a pretty good way to describe it. Why would you do that? I think I've got an ankle sprain, so no, I'm not going to give you an authorization to amputate my leg. The audacity of the hospital lawyer to beat up on Dr. Bourdain as if he's some sort of a paid expert. He told you under oath he's not even taken $1, and he gave you a succinct, reasonable description of why it is he decided to take this, the first case he's ever taken for a plaintiff, because it was insane, because it was indefensible. He used those exact words when he described what he saw here with regard to the administration of Precedex and the continued use of Precedex, despite a proven example on the 7th and the 8th of October of her overdose. And yet these defense lawyers want to soft pedal it. Like Mr. Francoia kept saying, well, if it's a medical event, it wasn't even a medical event, really. They're still coming into this court after all the evidence you've heard about the medical facts, not sympathy, but the medical facts that occurred on October 7th and October 8th. And their own expert, Dr. Goldberger, testified it was an overdose. And their own expert, the ethicist from Johns Hopkins they're so proud of, testified that this was a, quote, life-threatening event. So it's not some illusory manufactured occurrence. It happened. We know it happened. It's in the medical record. And their own experts admit that it was a life-threatening event and it was an overdose. And why didn't they learn from that? I mean, wouldn't a reasonable person think this particular patient had a terrible reaction to a set of medications at lower dosages than she received on October 13th, and she suffered that type of a, quote, adverse medical event? It's an overdose, and they knew it, and they should have learned from it. And had they learned from it, they wouldn't have prescribed it, they wouldn't have used it, or they would have been absolutely vigilant to the highest degree to look out for what happened to her in terms of the loss of her blood pressure and her hypoxic event. We're not running from the medicine under any circumstance. Mr. Goosey indicated to you under this made up topic of running from the medicine that this was an emergency situation. Well, let's look at the Precedex side effects that they knew about. You've seen this exhibit before. It's exhibit 37, I believe, and this is the insert for Precedex. And it indicates on this insert hypotension 24.6% an adverse event for vascular disorder. That's 1 out of 4 people are going to suffer hypotension or low blood pressure. And that's exactly what happened to Grace. Why didn't they know that? Why weren't they aware of it? Why weren't they vigilant about it? They could have avoided this whole thing. He wants to say this was an emergency situation and therefore they should be absolved from any liability because they had to do whatever they could possibly do under this emergency situation. Well, if it was an emergency situation on the 13th, what the heck was it on the 10th, on the 7th and the 8th, on October 7th and October 8th? Was this a continuing emergency situation that took place over a period of 6 days, nonstop emergent situation? Of course not. Of course it wasn't. And their own records indicate that they didn't believe that. So who's telling the truth? Which side of the aisle here is bringing you the truth? Which side of this aisle is bringing you the actual medical facts that allow you to make a well-reasoned decision? We are. I'm really outraged that Mr. Frankowiak took such great pains to beat up on Dr. Berdeen. You want to attack his qualifications because he doesn't personally order Precedex? Well, neither does Dr. Garibaldi. Why? Because they're in the ICU, okay? Because they're critical care physicians. They treat people who are on Precedex occasionally when it's used, when it's mandated, when it's considered to be a potential benefit. But just because he doesn't use it himself, well, guess what? He recognizes that figure. He recognizes the dangers and the likelihood of an adverse event when you use Precedex. But this is the same lawyer that brought you Julie Davis. Wants to argue about Dr. Berdeen and that he's got some agenda and he's not qualified to render an expert opinion in this case. I guarantee you that if Dr. Berdeen was not qualified to bring you an expert opinion for your consideration in this verdict, that man would have made that decision long before you came in and took those seats. That's what happens. That's why Dr. Berdeen was permitted to testify. 46 plus years of experience as a critical care physician. Yet they brought you Julie Davis. Wants to talk about Dr. Berdeen or why we only brought 2 experts in this case? Well, guess what, folks? We're now on Thursday. Is it Thursday already? 2.5, almost 3 weeks of trial testimony. If we had brought you as many experts as they thought they could load up on, we'd be here until July 1st. There's no need for that. The medical facts in this case dictated that on behalf of the plaintiff, we made a concerted effort to examine what we needed to present to you. We made that decision. And that decision was 1 nursing expert who was well qualified and a critical care physician with 46 years of medical practice. They brought you Julie Davis. They have absolutely no basis to try to tell you that our experts were unqualified. When they brought Julie Davis, they couldn't find a nurse in this entire country that wasn't working through some expert search service with 2 middlemen that were taking a cut of the fees. Come on. You could see through that. You could see that that woman was so unqualified to render a reasonable opinion that it was screaming out at us. Came up from Snellville, Georgia, had started doing this kind of work when she was a 2.5-year nurse. It's outrageous. We never saw any invoices for her work. Remember that? We talked about when she admitted that she couldn't understand exactly why her hourly rate was different from what she claimed it to be. Oh, that must be because there are 2 middlemen involved here. She didn't even know anything about Vident Partners, the expert witness search firm that tracked her down. And the last invoice we saw from her, if you recall, was December 15th. And she admitted she'd done a lot of work after December 15th. But we never saw an invoice. We have no idea as we sit here today what that law firm paid. It's outrageous. I guess you get what you pay for. Mr. Frankowiak kept saying to you, I want you to read between the lines. I want you to read between the lines. He made a comment about Dr. Berdeen betrays a distressing level of ignorance. How dare you? COVID caused her death. That was Mr. Frankowiak. COVID caused her death. Well, we brought into evidence the fact that they didn't want to give you that 1.4% people nationwide died from COVID. That fact is in evidence. He kept referring to those overdoses of October 7 and October 8 as, quote, some medical event of note. What? Some medical event of note? This is an overdose. Your own experts admitted it was an overdose. And because your clients refused to accept it, refused to look into the medical record, and refused to learn from what happened when Grace was overdosed on the 7th and 8th, and learn from it, you want to call it some medical event of note. Outrageous. He also said that it was false, quote unquote, false, for Dr. Berdeen to tell you that there was no pulse. That statement by Dr. Berdeen was false. Well, guess what? Another to hide from the truth. The reason Dr. Berdeen said that in that synopsis, that brief played on the screen for you earlier, where he included those words insane and indefensible, was because they were trying to put an arterial line into her. And it is just what it says, an arterial line. And you've heard as the medical facts have come out, you know, you've got veins that take the blood back to the heart. You have arteries that take oxygenated blood out to the extremities, including your brain, if you're getting sufficient oxygenated blood, and all the organs, all of your major organs. If you can't get an arterial line in when you're pricking the skin to find an artery, you have no blood pressure. That's what Dr. Berdeen was referring to. They couldn't get an arterial line. Remember I told you about the hose? I use an example of a hose. You turn the water off and a hose is just gonna lay flat. That's exactly what it looked like. Her artery was a hose when you turn the water off. They brought you 6 experts, among them a radiologist, Dr. Binstock, who I just referred to, admitted that his business, his life's work is looking at these films and that it's totally subjective. Think about that word. They brought an ethicist, and the best thing we got out of that ethicist was this was an overdose event on 10/7 and 10/8. They brought an infectious disease doctor, Dr. Fisk. We've got a slide on Dr. Fisk. He didn't know a thing about Grace except she had Down.
Is it the standard of
That's good. Go ahead.
care to administer morphine to a patient who is without a pulse?
So, in most situations, it is, I would say, it depends upon the cause of the lack of a pulse. But in general, morphine administration is not given to someone without a pulse.
And ask for the computer screen to be brought up. Oh, I'm sorry. And it's page 209 of the deposition transcript. Here you gave me a really not a straight answer, but in February you did. I asked you the question, is it standard of care to administer morphine to a patient who is without a pulse? And then it says there's some objections, but you're the witness. What was your answer?
Is no.
Is no. When forced, he tried to sort of wiggle out of it. There was an objection. He was allowed to answer the question. No. No. Judge is giving you the law, and we harped on this a little bit in my first opportunity to talk to you with regard to credibility. That's why we played that. Witness credibility. The clearness or lack of clearness of a witness recollection, the reasonableness of the witness testimony, bias or prejudice, facts and circumstances which tend to either support or discredit the testimony. Dr. Fisk knew he was in a box, and he didn't want to have to admit that until he was forced to, and until he was presented with the answer that he gave, the correct answer, which he had given in his previous sworn testimony. What does that help you to do? It helps you to determine those witnesses are not credible. You didn't see them able to do that with Dr. Berdine or with Nurse Susie Eichinger. Couldn't do it. Because why? They came in, they told the truth, and they were consistent. And their manner of testifying was such that they were direct, they were to the point, they answered the question. Who has credibility? Do we have credibility? Do our experts have credibility? Or do their 6 experts that they brought in to gang up on 2 when you only need 2? Okay, let's talk about the visitation policy briefly, and we can just get through this, John, on the video screen. We clear up this issue. We're putting up what's already been in evidence regarding the Ascension Hospital's visitation policy. I mentioned earlier, why do they have a policy if they're not allowing visitation? And why would they allow a policy if you've got an advocate with a power of attorney that's treated like a visitor and kicked out at 7 p.m.? Visitors are not allowed unless they meet the following exemptions. Designated support person, i.e., or example, a caregiver who tends to the needs of someone, concerns of a person with short or long-term limitations due to illness, injury, or disability. Clearly, Grace fit that category, and therefore, so did Jessica as a visitor. She wasn't actually a visitor, she was a power of attorney. Grace had Down syndrome. She was entitled to a support person. And it's undisputed from the evidence that for 47 hours, we counted them all up, we talked about it, for 47 hours, Grace was without an advocate or a support person. The entire day of October 10th was a failure by the hospital when they barred Jessica. Now, there's been some attempt to talk about those jury instructions and the verdict forms. If we could go to page 8, John. Let's zoom in on that paragraph that says, if you conclude. The judge has already given you the instructions. You'll have them. If you conclude from the evidence that the death of Grace Schara was caused jointly by Dr. Shokar's negligence and also by the natural progression of Grace Schara's COVID-19, then you should find that Dr. Shokar's negligence was a cause of her death. Doesn't have to be the cause, was a cause of her death. Let's go to the page 13, paragraph where the judge cites you to the law if you conclude from the evidence that the death of Grace Schara was caused jointly by the negligence of the registered nurses at St. Elizabeth Hospital and also by the natural progression of Grace Schara's COVID-19, then you should find that the registered nurse's negligence was a cause of her death. That's the law. We also want to look at the page 13, a person's negligence is a cause of a plaintiff's injuries or death. That's the section that says, if you conclude from the evidence that the death of Grace Schara was caused jointly by the negligence of the registered nurses at St. Elizabeth Hospital and also by the natural progression of Grace's COVID-19, then you should find that the registered nurse's negligence was a cause of her death. You can find that based upon the evidence. All of this discussion about COVID-19 is a distraction because these actual jury instructions tell you that even with COVID-19, you can still find that Dr. Shokar is still on the hook. The jury instructions tell you that even with COVID-19, you can still find that the hospital through its nurses is also on the hook. Let's go to the verdict itself, because that's what's going to help guide you when you begin your deliberations. We look at the verdict form. Question number 1. Was Dr. Gavin Shokar negligent with regard to the care and treatment he provided Grace Schara on October 12th and 13th? That question does not relate to October 10th. It doesn't even relate to October 7th or 8th. Was he negligent with regard to the care and treatment on the 12th and 13th? Answer is yes. You then move on to question 1A. I know the judge went through this with you, but I need to make sure you completely understand how you're going to go about answering this verdict form, because at first blush it looks a little bit complicated, but if you work your way through it, you'll find that it makes perfect sense. I've been working for 2 days to get this right. Question 1A, we find Dr. Gavin Shokar violated the standard of care by allowing the ongoing administration of Precedex to Grace Schara on October 12th. Answer is yes. We find that Dr. Gavin Shokar violated standard of care by allowing the ongoing administration of Precedex October 13th. Answer is also yes. We find that Dr. Gavin Shokar was negligent by ordering the use of lorazepam on October 13th. You've already heard so much information about the effect of combining these medications, and that's what this question gets at, and the answer to that question is also yes. We find that Dr. Gavin Shokar was negligent by ordering the use of lorazepam. Question 1C, yes. Question 1D, we find Dr. Gavin Shokar negligent by the ordering the use of morphine on October 13th. The answer is emphatically, all caps, yes. Dr. Burdine told you the worst clinical decision he has seen in over 46 years of medical practice. That's how you answer that question. Answer question 2 if you answered yes to question 1, of course you have. Was such negligence by Dr. Gavin Shokar a cause of injury or death? So this is the corollary question after you found that he violated the standard of care, that he was negligent. Then you're asked, was it a cause of injury and or death? And the answer to that has been proven yes also. Question 3, was Dr. Shokar negligent in informing Grace and or her power of attorney about the availability of reasonable alternative medical modes of treatment and about the risks and benefits of these treatments with regard to the care and treatment on October 12 and 13? Yes. How do you know that? Because he continued Precedex. He ordered lorazepam. He ordered morphine. And he failed to notify the family that he had placed a DNR order in her record. And you heard Julie Davis, their nursing expert, say, when I asked her about the ability to see the record, which I thought was really kind of a dumb question, but she gave it to me. Of course, the family can't see the medical record, so how would they know that a DNR had been ordered, that a DNR was placed in the chart? And Nurse Davis said, well, you don't have access to the chart until the conclusion of care, or if the patient is dead, and her answer was the conclusion of care. Then we go to question 3A. We find that the standard of care required Dr. Shokar to get informed consent prior to ordering morphine on October 13th, and he failed to satisfy that standard of care. There's been plenty of testimony on that point also, and the answer is yes. Question 3B, we find the standard of care required Dr. Shokar to get informed consent prior to verbally ordering lorazepam on October 13th, and he failed to satisfy that standard of care. Of course. Of course he did. Answer is yes. Dr. Shokar violated the standard of care by placing a DNR order without informed consent. We talked about this. What does informed consent require? The answer to that question also is yes. Question number 4. Was such negligence by Dr. Shokar in informing Grace Schara and or her power of attorney a cause of injury and or death? Yes. Once again, continuing Precedex, lorazepam, morphine, and failed to notify the family that a DNR order was in Grace's chart. Question 5. Were one or more of the nurses at St. Elizabeth Hospital negligent with regard to the care and treatment provided to Grace Schara between October 6th and October 13th? Note that in this question, the judge is asking, were one or more of the nurses negligent? Answer is yes. Question 5A, we find the standard of care required the nurses at St. Elizabeth Hospital to inform Grace Schara or power of attorney of the medical event on October 7th involving Precedex. Failed to inform Grace or her power of attorney. And of course, they failed to satisfy the standard of care. The answer to question 5A is yes. Question 5B, we find the standard of care required the nurses at St. Elizabeth to inform Grace or her power of attorney of the medical event on October 8th. So 5A goes to the October 7th overdose, and question 5B goes to the October 8th overdose involving Precedex, and they failed to satisfy that standard of care. The answer is yes. Question 5C, we find the standard of care required the nurses at St. Elizabeth Hospital to communicate with Grace or her power of attorney, and they failed to satisfy that standard of care on October 10th. Why? Because Jessica had been barred from entering the hospital as the patient advocate. You recall that the Schara family had to hire a lawyer in order to get Jessica into Grace's room. Answer is yes. Question 5D, we find that standard of care required the nurse at St. Elizabeth to communicate with Grace or the power of attorney in creating a plan to get a replacement for Scott on October 10th, and they failed to satisfy that standard of care. Answer is yes. Question 5E, we find the standard of care required the nurses at St. Elizabeth Hospital to communicate with Grace or her power of attorney, and they failed to satisfy that standard of care on October 13th. Why? Why is the answer yes? Because they failed to notify the family of the DNR order, and they failed to place a DNR bracelet on their daughter, on Grace Schara. Question 5F. We find that Grace Schara's family revoked the DNR order on October 13th and communicated that decision to the nurses at St. Elizabeth Hospital. Further, we find that the standard of care required the nurses at St. Elizabeth to take immediate action at the time they were informed of the decision to revoke the DNR order, and they failed to satisfy that standard of care. Answer, yes. So, question 6, only if you've answered yes to question 5, right? Was such negligence, this is the cause question, was such negligence by one or more of the nurses at St. Elizabeth a cause of injury and or death to Grace? The answer is yes. Then you go to question 7. If you've answered yes to 2 or more, question 2 and question 4 and or question 6, assume assuming that the total negligence caused Grace Schara's injury and or death to be 100%, what percentage do you attribute to the following? And your choices are to establish a percentage of negligence between Dr. Shokar and the nurses at St. Elizabeth Hospital. The amount must reach 100%. You have, based upon your collective wisdom and your review of the evidence, the ability to attribute this negligence either 50-50, 100%, however you want to do it. Question 8, what sum of money will fairly and reasonably compensate plaintiffs for Grace Schara's death with respect to? And the court has already put the number for the funeral and burial expenses in because that number is not in controversy and therefore you don't have to decide it. It's already there for you. And now the issue becomes, what amount of money do you attribute to the personal injuries for the lack of informed consent? And in C, pain and suffering. And this gets back to that very difficult question that we deal with in these cases, and that's why I was in a position to say to you during the jury selection process, if you're selected to serve on this jury, and what I was getting at is if you end up sitting here now at almost 2:30 on a Thursday afternoon, will you be able to award a monetary amount? And I mentioned the dollar amount of $10 million. I'm suggesting to you that based upon how egregious this case is and what she suffered, that amount is a starting point. You have the ability to go up or down. You can award more than $10 million. The evidence showed that she suffered life-threatening events where she was almost gone. Two times, and then the third time she died. And if you've heard people talk about seeing my life pass before me in those moments before death, she suffered 3 times that life passing before her. What is that worth? Ask yourselves, what is the life of a 19-year-old daughter, sister, aunt, a lovely girl who enjoyed life? What is that life worth? I recognize that it's a difficult question, but it's one that the law in this case requires you to answer. Ladies and gentlemen, we have been together for a long time. We're into our 3rd week, and you are now about to have this case delivered to you to decide. We've been working every day to try to show you the truth in this case. I am so proud of the lawyers on our team who have worked tirelessly, many hours outside of what you even observed in order to get this case to you. I know it's been hard, and I know you spent time away from your jobs, away from your family. We know that you're not making $12,000 a day to sit here. We understand that. We know that there's been a lot of complex medicine in this case and a lot of red herrings. And it's going to be your job now to go back into that jury room and sit down. And your first task is going to be to select a 4-person of this jury. And when that happens, I'm going to ask you all to reflect deeply and ask yourself whether you're best equipped to do that. That you are the most fair and impartial of your group to do that. And it can be a difficult job at times. You're going to have a lot of competing voices. There's going to be a lot of conversation. There's going to be a lot of discussion. It's going to be the foreperson's job to manage that discussion, to keep it orderly, and to keep it focused on the evidence and the law, and to return a fair verdict on behalf of the plaintiff. I encourage you to volunteer as a foreperson if you feel you're capable, and consider the opinions of the other jurors, but do not give up your position merely to be congenial or polite. Stick to your guns, but return a fair and just verdict. I trust that you will. And I trust that you recognize that we have not only proven this case by a single feather, but by a whole flock of feathers. Thank you.
Thank you, Attorney Administrator. Members of the jury, this case is now ready to be submitted to you for your serious deliberation. Consider the case fairly, honestly, impartially, and in light of reason and common sense. Give each question in the verdict your careful and conscientious consideration. In answering each question, free your minds of all feelings of sympathy, bias, and prejudice. Let your verdict speak the truth, whatever the truth may be. When you retire to the jury room, your first duty will be to elect a juror who will preside over your deliberations and write in the answers that you have agreed to. The voting or the vote of the presiding juror, however, is entitled to no greater weight than the vote of any other juror. When your deliberations are concluded and your answers are inserted in the verdict, the presiding judge will sign and date the verdict, and you'll let the bailiffs know that you have a completed verdict. And at that point, all of us will return into this courtroom to have that verdict read into the record. I would like the clerk to announce the alternates.
Alternate number 1, juror number 386. Alternate number 2, juror number 2749. And alternate number 3, juror number 2419.
Okay. The three of you have been selected as alternates, and we're going to start that process in just a minute, but I'm going to ask that the bailiffs please come up and have the clerk swear you in.
And each of you do swear that you will, to the utmost of your ability, keep all jurors sworn on this trial together in some private and convenient place, subject to the direction of the court, until they have agreed on their verdict or are discharged by the court, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon. So help you God.
Ask one of the bailiffs is going to take the three alternate jurors down to the jury room. The alternate jurors, the process for right now will be for you to grab whatever is yours out of that jury room, your notebooks, your jackets or purses, whatever you have, and then you're going to come back down into the courtroom, and the rest of us are going to be waiting for the three of you to come back. So will the bailiffs please take the alternate jurors? For the remaining jurors, just a couple of things, and we can always go through this, but I just try to short circuit some things. So I said it earlier that if you have any questions for me or you need something, you probably understand that I'm going to do what I can to get you what you need. an exhibit or something else that you need. If you write me a letter by the foreperson, be as specific as possible. And that might be challenging for you, but if you can be specific as possible, most of the time I'm going to meet with everybody and then you're going to get my answer in writing, signed by me, and I'm just going to give you that same sheet of paper back. If it gets more complicated, every once in a while I'll bring the 12 of you back in here and I'll give you some verbal answers, just if it's going to take too long to write down. When you're waiting for me to answer that, continue your deliberations, because it may take 15 or 20 minutes for us to get everybody together and then answer it and get it back to you. The other thing, and now that it's relevant for you, is we will knock at 4:30. So if we don't hear from you before 4:30, you should understand that one of the bailiffs will knock on the door and ask you that question about what you want to do today. That is not intended to bother you or disrupt you, and you're not going to hear from me in any other circumstance than that. So I'm just going to be back in my office and I'm going to wait to hear from you. And that'll be the same case, if we show up tomorrow, you're only going to hear at 11:30 or, half hour before lunch and then a half hour before dinner. And that's just the normal process. When you go back to the jury room, these original documents will be brought in it'll be a couple minutes after you get back there, because I want to talk to the attorneys and make sure I get approval. Is there any objection?
No, sir.
Attorney Frankowiak?
No, Your Honor.
Okay, so then I will give those to the bailiff now. These are the original ones. They're not stapled. They have paper clips on it. So you all have stapled copies. When you're done with your verdict, I will need the originals back of the verdict and the instructions along, the verdict will be completed. All right, the alternates are back. And so at this time, the 12 jurors who have been selected to serve as jurors, you're going to be free to go to the jury room, begin your deliberations, take your verdict forms and the instructions that I gave to you this morning with you. So you can take your sheets that I gave you. The jury is excused. Bill? All right, everyone may be seated. The 3 alternates are here. The 12 jurors are excused. I can't say much to you because it's as if you're in deliberations, but what I will tell you is the plan right now will be that the 3 of you are going to go down to a separate jury room. You'll have your phones and whatever else you need. You just continue to contact with the bailiff. The rules are still the same, so you're prohibited from speaking with each other or with anyone about anything involved in this case. So you're still part of this case. And I told those jurors that the first time I'm going to bother them or contact them is at 4:30. And so when we get their answer at 4:30, a bailiff will let you know what their answer is, so you know what the plan is. If you need anything, there'll be a juror or a bailiff outside your door, and just communicate with them, and I'm going to be in the back and answering questions. I hope that's enough, but if you have additional questions, write it down, put your number on it, get it to a bailiff, and then I'll answer it in writing. Are the alternate jurors free to leave, Mr. Administrator?
Approach.
Yes. Make mistakes and I forget to say something, so the attorneys just reminded me, because you probably are sitting there going, well, why did I get picked or something? Yesterday I was in the middle of our meeting, somewhere in around 1 o'clock or 2 o'clock. We put all 15 names of the jurors, or we didn't put your names, put your numbers into a basket, and the clerk spun it around, which is the format that we use. The clerk reached in and pulled out the 3 numbers that are yours. So it wasn't done by me, it wasn't done by the attorneys, it was done in that method. You're not, and you know, in fairness, you're not excused yet. So, you know, you're still our jurors and should be ready to go because it's not unusual that something happens and one or more of you are going to be asked to go into that room. Okay. Thanks for that reminder, counsel. The alternate jurors are excused. All right, everyone may be seated. Any issues, questions, concerns? Start with you, Mr. Administrator, regarding the reading of the instructions, the closing arguments, or anything that we did today.
No, Your Honor.
Attorney Guzzi.
No, Your Honor.
Okay, Attorney Frankowiak.
No, Your Honor.
Okay, I received from you during that last break, Attorney Boylan, a request to seal. Have people had an opportunity to review that? Okay, and so we should probably talk about it at some point. I think if you guys want to take a break, but nothing's published yet, I don't believe. And so, okay. Oh, you filed, I didn't get it until noon, the noon hour. So here's a question. Is there any reason not to seal all of the medical records? I think that was part of the request.
Yeah, absolutely.
Okay, and if there's anything else sealed, or you want to be sealed, like when I was going through that list, like Ms. McGinnis's time card, for example, that wouldn't be part of a medical record, so it's not in that batch. But I don't know if I'm gonna provide you a list right now that I just went through as you were closing, Mr. Administrator. You guys can write them down, and if you think there's something in addition to the numbers that I'm giving, I'd like you to kind of speak out or Exhibit 447, Exhibit 41 through 46, and Exhibit 49. Exhibit 53, 54, 56 through 59, 71, and 72. Exhibit 67, Exhibit 374, 443, and 444. Exhibit 230 and 231. And then exhibits 233 through 238. Exhibit 232, 428, and then exhibit 430 through 440. Exhibit 441, 445, and 446. Exhibit 86 and 87. Exhibit 205, 212, 214, 217, 218 through 220, and then 222. Exhibit 366, Exhibit 1, which I think we've covered. Exhibit 362 and 363, 372 and 442, 372 and 442, 103, 100, and 102, And I don't think that includes the 259 and 413 that you asked for in your letter, Attorney Boylan. So remind me what those two documents were.
Portions of the medical record as well to have.
Okay. So, okay, the death certificate is, yeah, 413. Any objection including that? Okay, so 413 is sealed, and then what's 259? And so as you're looking for that, what I want the attorneys to know is that list that I just gave of the medical records. My understanding is those are all of the medical records other than exhibit number 1. If you think there's something more, do that soon, because if they ask a question about getting medical records, my thought is that those are the numbers we're going to give them. Instead of giving them exhibit number 1, remember that discussion during the trial. If they ask for something specific, we'll give them that specific medical record. But if they were to say, well, we want like the notes from the nurse, you know, those are the numbers that are here. And if you want to go through those, you know, I'll keep these out or with the clerk during the break. But what she did was just got to me each of the exhibits day by day, and I just highlighted yellow, and then the yellow's attached. So like this stack could be ready to go to the jury, and I think those are the medical records. What's 259? Okay, so 259 will be sealed. So all of the documents that we just numbered will be sealed based upon the agreement of the parties. Anything else on your letter, Attorney Boylan, then? Anything else on exhibits from the plaintiff?
No, sir.
Anything else on exhibits from the defense?
No, Your Honor.
Okay. You know, what's the process or what do you guys want to do? Because I'd like everybody to stick tight for 15, 20 minutes in case we get a quick question and we can respond. And then at some point, I'd like a lead counsel that's going to be back here, you know, within 10 or 15 minutes if we need you to be back here. And a cell phone number that you leave with the clerk so we can call, you know, that number. If the parties want to be here, they're not required to be here. And so it's up to each side to decide who wants to be here. But they should also be under that same rule. So if there's a question, I'd want them to be back within 10 minutes if they want to be part of it. Is that any issues with that, Mr. Administrator?
No, sir. No, Your Honor. No, Your Honor.
Okay. Anything else? Okay, we'll wait to hear from them and then we'll be in touch. We're adjourned.
There we go. So this is Scott Schara's sworn testimony. And we're starting, would that have changed your thought process on whether or not you'd have Grace intubated? They're talking about a discussion between Mr. Schara and Dr. Shokar, right? That whole, you've heard about it countless times. And the question, would it have changed? And his answer, if he said to me, the only way to save her life is with intubation, would it have changed my mind? Yes, it would have changed my mind. So that's the testimony of Mr. Schara. And that question was posed to him by Mr. Goosey. He sat there face to face with Mr. Schara and asked him that question and got that answer under oath. So for him to come into this courtroom, along with his partner, Mr. Frankowiak, and try to claim that Mr. Schara made a reasoned decision with informed consent, being that he was not going to allow for intubation under any circumstances, is a blatant falsehood. And he knows it because he got that answer over a year ago under oath. Mr. Schara said he wasn't willing to give pre-authorization. And I think he used the example, that's like if I were to go into the hospital with a sprained ankle and they asked me to give a pre-authorization to amputate my leg. I thought that was a pretty good way to describe it. Why would you do that? I think I've got an ankle sprain, so no, I'm not going to give you an authorization to amputate my leg. The audacity of the hospital lawyer to beat up on Dr. Bourdain as if he's some sort of a paid expert. He told you under oath he's not even taken $1, and he gave you a succinct, reasonable description of why it is he decided to take this, the first case he's ever taken for a plaintiff, because it was insane, because it was indefensible. He used those exact words when he described
you by the greater weight of the credible evidence to a reasonable certainty. Keyword is credible. Can't be just any old feather. It has to be a credible feather. Reasonable certainty means that you are persuaded based upon a rational consideration of the evidence. Absolutely